Good morning, our viewership. Good morning, members of the Uganda Law Society. Once again, my name is Conveyacing John Chris, and I'll be moderating this CLE event, the very first CLE of this year. So allow me to briefly begin with a word of prayer, then we can start with this training. In the name of the Father, and of the Son, and the Holy Spirit. Amen. Father Almighty, we thank you for today. We thank you for having gathered us here. We pray that you may send down your Spirit upon us, that you may guide our speakers, our moderators, and the membership, that you may benefit from this event. We ask for this through Jesus Christ our Lord. Amen. In the name of the Father, and of the Son, and the Holy Spirit. Amen. So yes, like I said, my name is Conveyacing John Chris. I'm an advocate of the High Court of Uganda, practicing with Messrs. Taremo and Company Advocates. Today, we are having a CLE training under the theme of land law, emerging areas, land law and conveyancing. We have a couple of speakers, 4 speakers, who will be making various presentations, after which we shall invite the membership to ask questions, depending on the observations from the said presentations by the speakers. So, without further delay, allow me to invite the Vice President of the Uganda Law Society of the Radical New Bar to give his opening remarks. Then we shall have the first speaker. Thank you.
Good morning.
Yes, we can hear you.
All right, thank you very much. Good morning, esteemed colleagues and members of the Radical New. It is my, this is the first CLE training of this year, 2025. This session aims to provide valuable insights into the evolving landscape of land law, equipping you with the instructions. Our training today will drive into key aspects of land law and conveyancing, with a particular focus on mortgages and conveyancing. We will explore this area of managing and advising on mortgage-related matters. We'll also take a closer look at land tenure systems, examining the different structures under which land is held and the rights that accrue to landlords under each system. Understanding these rights is essential for practitioners as they form the foundation of many legal decisions and disputes in land transactions. In addition, we'll discuss the role of surveying in land transactions. As many of you know, accurate and reliable surveyors are fundamental in ensuring the validity and clarity of land titles, and it is crucial to understand the various technical and legal aspects that come into play during land surveying. Lastly, I will provide key considerations for drafting pleadings and agreements in land transactions. Whether you are negotiating, litigating, or drafting legal documents, these skills are vital in ensuring that the agreements reflect the true intentions of the parties while safeguarding their legal rights. Throughout this training, we encourage active participation, questions, and discussions. I would like to thank all of you for the commitment to enhancing your expertise in this critical area of law. We are confident that the knowledge you gain today will not only strengthen your practice, but also improve the quality of legal services provided to clients involved in land transactions. Thank you very much, and I look forward to a fruitful and engaging session. I wish you all the best. Thank you.
Thank you very much, Mr. Asimwe Anthony, our dearest Vice President of this Radical New Bar. You've fully given a comprehensive summary of what topics are to be covered today. So allow me to introduce our first speaker, Mr. Tudiahikayo Alan Mujisha. Just a brief summary of our speaker's biography. Just like me and many members on this table, he's an advocate of the High Court of Uganda, having pursued his bachelor's law degree from Makerere University and his diploma in legal practice from the Law Development Center. He also has a bachelor's degree in land management and valuation from the University of Dar es Salaam. He has a master's in business administration from Isami Business School. He's currently a PhD student at Adi University, Dar es Salaam. He's a managing partner of SM Kathan Property Consult Limited. He has held various positions. He's a former council member and honorary secretary of the Institution of Surveyors in Uganda, a position he held from 2007 to 2017. He's a registered valuer with Surveyors Registration Board, Uganda, and is currently a trustee of the International Ethics Council, representing the Institution of Surveyors in Uganda, and is also a member of the Members and Standards Registration Board of the International Valuation Standards Council. So I invite you, Mr. Tudiahikayo, to make your presentation, which I'm very certain the membership will benefit from. Thank you.
Thank you very much, the moderator, Mr. Kawesi, and good morning, fellow panelists, and good morning, should we say viewers, should we say listeners. So I think the introduction has been elaborate enough. My role really here is to take you through some broad aspects of land survey and the importance of land survey in land transactions. And I think, Mr. Kawesi, your choice in me being the first to speak is probably the right one, because it provides a foundation for the discussion. So I've got a presentation that I think the team is going to be beaming, and I'll just try and speak off the slides. And of course, I'll leave the slides behind for anyone who wants any further information. So generally speaking, land survey is pretty much the field or the profession or the science of measuring and recording land. And it has been written by various scholars that on the continent of Africa, land survey dates as far as back as 13 BC, or rather 3000 BC, where we have evidence of maps of the first floods of the Nile Basin in Egypt, showing evidence that there was survey at that time. There is also evidence that the pyramid of Giza, which was built over 26 years, and is dates as far as 2600 BC, has got detailed maps that preceded its design and its construction. And for those who are believers, like I am, the Bible has got evidence and uses language that is still prevalent today. For instance, in Deuteronomy chapter 19, verse 14, you will read, depending on your verse, you will read lines like, "You shall not remove landmarks that have been put in place by our old ancestors." In Proverbs chapter 22, verse 28, there is a line that forbids and says that do not cheat your neighbor by moving boundary markers. And in Job chapter 24, verse 2, there is evidence that even at that time, there were individuals who were known to have the habit or to be in the practice of moving boundary markstones. So, Mr. Moderator, you'll note that the wording being used by the Bible, even at that time, talks about or uses words that are still valid in today's language, like boundary markers and markstones and so on and so forth. So you can see that we're not talking about something that is new. This is something that has evolved over a long period of time. And at this point, I'd just like to take you through a few broad concepts about land survey to give us some good foundation with what we are discussing. So, Mr. Moderator, the essence of land survey, or the entire process of land survey, is reduced in what we call the cadastre. The cadastre is a word that evolves from Greek and the French languages that really means a list or an organized schedule or organized record of things. But for land, it was taken as a universal word to refer to all the records that pertain the measurement and the recording of measure of land. And so any national system that has got records of land measurement, which I think is now quite acceptably universal, is called a cadastre. So when you find that word, the simple meaning for it is a record of land and measurement of land. Secondly, I would just like to talk about what we call the torrent system of land registration. So just like anything else, the earlier times or in the beginning of society and development of society, the question of private property was not a big deal. Yeah, so people lived in communities, and private ownership has only evolved recently. And so land registration was a preserve of the state and a preserve of big entities like kingdoms, which were defining what was community land and so on and so forth. But over time, it became, it occasioned that land transactions were now becoming more and more private, and the general tendency towards personalization of property became more and more prominent. And so many countries faced challenges of keeping records that were capable of being updated and being referred to efficiently. And so it was not until 1858 that Sir Robert Torrens, who was an Australian at the time, invented the current torrent system, which has largely remained as it was invented then. So the difference with the torrent system and other systems of land registration is that, number one, the system is designed to have all records pertaining a parcel to appear on the same jacket of information that parcel is kept. And so it means that for you to know what is going on or what is the status of a piece of title, you only need to refer to one record. So you don't have to understand the 30-year history of a piece of land in order for you to do a due diligence on it. So if you found, say, for example, maybe this is plot, I don't know, the ULS office could be, say, plot 4, Acacia Avenue, right? And so if I went to the land office and I'm trying to do a search on this property, I would not have to go beyond the face of what I find on the white page of plot 4. And so that aspect of being holistic made it very efficient. And therefore, most Commonwealth systems of land registration are using the torrent system, including Uganda. So some of the advantages of the torrent system is that, number one, like I mentioned, it has got universal content of information. So you're talking about your land size, you're talking about the shape of the land, you're talking about the parcel number, you're talking about the block and other administrative zones that in which that land is. You're talking about aspects to do with the ownership, including history of ownership. Yeah, because again you find all that in the jacket of the title. You also find things like encumbrances. So if there are any mortgages, if there are any easements, if there are any rights of way for or against that title, you'll find it in that same jacket. So number two is that this particular system is state guaranteed. So the primary role of keeping a true record of land is actually borne by the state. Yeah, so to mean that the state guarantees that if you do come to the record or the registry and you find a particular record as kept by the government and you use that information to make a decision, then the state is guaranteeing you that that information is true and correct to the extent of your reasonable examination of that particular record. So again, that gives comfort and allows transactions again to, or various parties to be confident that there is an independent entity that is guaranteeing the content and the true record of land. And then those two combined mean that that title is then indefeasible. So you cannot challenge the title because it's guaranteed by the highest organ of orderliness and the biggest defender of the law, which is the state. And so when a title is indefeasible, that means that again it allows third parties to go ahead and make decisions based on the guarantees that have been provided. And then the other thing that is important to understand under the torrent system, and I think this is very important if you don't choose to remember anything else that I say about the torrent system, is what we provide an acronym as FIFO. FIFO is basically fast in and fast out. Yeah. So by way of example, the torrent system dictates that if I make my record of ownership or claim on the title and I go ahead and record it, even if that right arose at a date that is after yours arose and you are not vigilant enough to go and record it, then I take priority over, my interest takes priority over yours. So by way of example, I sell you a piece of land today. We signed an agreement dated, today is 20th, and probably the time is now 9:36. If you are careful enough, if you examine the entries of ownership or even of interests on titles, you would find that it provides for a date, it provides for a time in which that particular entry was made. And that is intentional because it is important that date and time is recorded to challenge, or to precede or to avoid any claims of ownership that could have come in at the same time. So a day is not enough. So again, following through the example I was trying to put across, I sell you a piece of land today, and we sign an agreement dated today, and as you know, most agreements never have a time on them, they just have a date. If I went ahead and transacted with, say, my co-panelist here on the same property in the afternoon, and she was vigilant enough to go and register it, and for you it took slightly longer. Now, even if it was erroneous or illegal for me to sell the same property to another party, if she went and registered her interest, and that transaction is void of fraud on her part, obviously it is clear that it is fraudulent on my part, but if on her part, she's a bona fide purchaser for value, and she goes ahead and registers her interest even having existed after yours, is actually takes more precedence in terms of the torrent system than yours. So that's what's quite important to understand, and therefore it is it's advisable that as lawyers we understand that part in terms of protecting our interests and the interests of our clients. So another thing I would just like to mention about in terms of the essence of survey is that like any product, like any commercial product, for a transaction to be able to take effect, yeah, there's got to be reasonable definition of the subject matter, yeah. So that's why you see agreements talking about sale agreement, land at, block this, plot this, location this, village this, and so on and so forth. The idea there is to try as much as possible to define the subject. Now, as you very well know, is that land in itself is a wide notion. So in order for us to be able to define what land is, then survey becomes very important. And so, again, using the example of this address, when I say plot 4, Acacia Avenue, I am not talking about very many other properties because it is very clear where plot 4 Acacia Avenue is. And so the discussions can then be on other things apart from defining and understanding what plot 4 Acacia Avenue is. So again, land survey plays a critical role. But beyond, and this is very important, beyond physical land holding, survey has allowed, by operation of law and ingenuity and innovation, for there to be more than just the physical definition of land, in order for that to be an aspect of transaction. And so on plot 4, Acacia Avenue, we can have, apart from the physical land itself, we can have layers of rights and interests on that land. But also that is occasioned because the very foundation of the land itself is already defined. So on plot 4, Acacia Avenue, yeah, we can have, say, it could be a freehold, isn't it? Under the freehold, we could still have a 99-year lease on the same plot 4, Acacia Avenue. So again, there you see, there are already two holders on the same property. Under the same leasehold, you can have a sublease of plot 4, Acacia Avenue. So that's the third one. Under the same property, you can have a tenancy, all right? Under the same property, you can have what we call strata titles. So for instance, plot 4 Acacia has now been developed with this wonderful institutional office complex. But each floor can have its own title under the strata or vertical property ownership concept, yeah? So again, the fundamental is the plot 4 and the definition of the 4 corners and the coordinates of the 4 corners, but you realize I've already mentioned about 6, 7 layers of interests that can be extracted out of that. Not to mention other things, for example, mortgages that can be registered on the same title. And remember, a mortgage can be registered on each of those various titles I have mentioned. I can have a mortgage on the freehold, on the leasehold, on the sublease, on the tenancy, if it is something that is weighty. I can have mortgages on each of the strata titles that are created. So again, you see, survey being a foundation, by operation of law, is allowing several interests and processes to be held under that. And then, of course, that commercializes and optimizes land. And that's a very big concept in land economics, that we will try to create value over, you were trying to defeat the notion that land is fixed, and therefore it is fixed in supply. So what we do, we use ingenuity to create a wide range of interests that are probably beyond even limit by operation of these foundations of survey and, of course, law. And then the other one I'd like to talk about is the Latin maxim of quid plantata solo solo sed it, which basically means that anything that exists on land, permanently exists on land, yeah, is part of land. And that is a concept that, of course, also is very fluid and allows very many notions of urban economics, yeah, to begin taking root, and then also allows, it gives confidence in dealing with titles for development purposes. Because land in itself, especially when we are talking about, heavily dense populated areas, land in itself ceases to be an end, it's only a means. And so these principles help, to kind of give confidence in the whole process, for example, property financing. Yeah? So whereas the registry has got plot 4, and whereas the bank has put a mortgage, or a financial has put a mortgage on plot 4, this maxim allows the bank to have comfort that everything on plot 4, which I have financed, is still part of what? And therefore gives me the confidence to invest. So again, that is something very heavy when we talk about land management and financing of landed developments in general. And of course, finally, you'll all agree with me that all these things are creatures of statutes. The Constitution is very clear on the right to property. The Survey Act domesticates all survey practices globally in their dynamism as principles that are applicable for training and application in this country. The Surveyors Registration Act, however old, provides for just like any other profession that is governed in the country. So this provides for the training, registration, and practice of land surveyors and the other related fields. The Land Act is, of course, as you all know, and I'm sure other people will discuss in detail here on issues of tenure and so on and so forth, and of course the Registration of Titles Act. And by those 3 dots in the presentation, I mean that there are several other aspects, or rather of the law and subsidiary law that apply to the governance of land in this country in general. So if the technical team can help me go to the next slide, I'd just like to talk about a little bit about the types of boundaries. So, whereas we are all used to what I'm highlighting there as bullet number 4, as individual boundaries. I think this is what many of us end up getting involved in. But boundaries are far and wide, yeah? So the high seas have got what we call maritime boundaries. These are the ones that define international waters from state-controlled waters. And this is a whole big subject. It's a whole big, field of science. And there's a lot of debate that is going on around the rights of countries and the universality of the ownership of the high seas by all states, whether they are landlocked or otherwise. So those are these big discussions that are going on. But again, I'll leave that for another day. But we all know that the globe is made out of several continents, and these continents have got a definition. So whereas the definition is largely defined by oceans, but it is in there is survey itself. And of course, modernity has allowed us to do very accurate mass surveys to define continents, to define subcontinents, to define countries, yeah, and to define states. And countries that are federal in nature, like the United States and other countries, I think Kenya even has also adopted a federal governance system. They are state boundaries. Yeah. So if you're a governor of a state, your territory is defined by survey, essentially, because then you are a governor in a particular geographical space, isn't it? And that is aided by survey. Some countries have got regional administrative zones, and of course, like ours, we've got districts. Every district has got very clear boundaries, and in fact, there's a map that defines these districts. I'll be talking more about that when we get to the transactional aspects that land survey really supports. But again, of course, there are your individual boundaries. The best example is the usual estates that have come up over the last few years by estate developers. And so they are selling you plots, and those plots are normally demarcated by either boundary concrete beacons, yeah, or upright concrete pillars or fences or natural hedges. Again, those are boundaries, and you use those to enforce your ownership. Yeah, you use those to define what belongs to you and what belongs to a neighbor and what is common to all of you. So again, this gives you a background of how important survey is, because you cannot begin to claim until you understand and there is common knowledge between you and your neighbors about what defines your property and what doesn't. And so again, all that is quietly embedded in the profession of survey. And then, of course, there are also boundaries by form. And these are in the past, before land measurement science was that developed, a lot of boundaries were by natural features. Yeah. So continents are largely defined by oceans, coastal boundaries. Countries are defined by rivers, defined by swamps, defined by forest areas, and in some cases we even have natural infrastructure. Say, for example, roads in many cases are used to divide between different zones. But I think what everyone is keen on here is the artificial boundaries we have created to define what belongs to us. Yeah. So again, I think that is what is key, a key takeaway. And by artificial, I mean you get onto a property, you negotiate that you're buying a portion of a bigger chunk of land, you agree on which side of the bigger chunk of land you'd like to buy. You also agree the extent of what you're buying, say maybe 10 acres or 100 acres, and then you go and call an expert to come and demarcate that off for you. So again, those are artificial boundaries that allow us to define what belongs to us, and therefore go ahead and make decisions which are transactional in nature for us to achieve whatever goal we want for that piece of property. Next slide, please. So, Mr. Moderator, this is where the gist of the matter is, and I'd just like to concentrate and end on this particular slide. So, what are the clear roles of survey in aiding transactions? So, number one is what I've alluded to, which is what I'm calling sovereign extents. Yeah, and this is interesting because we don't begin to be a nation until it is very clear what the demarcation of our extent is. Yeah, and so when you say Uganda, you're referring to a group of old men or old women some time back who decided the extent of Uganda. And therefore, for those of you who travel quite a bit, you're able to get to a point and they tell you, you are now in Uganda and you are now not in Uganda. Now, physically, you don't see anything. Yeah, there's no fence, like some leaders in America are trying to do. But there's a known demarcation between what Sudan is and what Uganda is, what DRC Congo is and what Uganda is, what Kenya is and what Uganda is, and Tanzania, Rwanda, and all our neighbors. So there is territory where we know the extents, and breach of which is breach of the sovereign independence. And of course, we know there is evidence that there have been wars that have been devastating, which have become as a result of boundary disputes or resource disputes between nations. And of course, the history of it doesn't matter. But the fact is that the non-clarity of survey is also creates issues of clarity of sovereign extents of several countries. Then slightly after that, we all know that the globe is under different systems of governance, isn't it? But one of the most prominent, including our own, is democracy. So again, Uganda is riddled with over probably 3,000 electoral positions, but most of them, if not all of them, are hinged on an administrative zone. So a village has got a boundary, a parish has got a boundary, a sub-county has got a boundary, a district has got a boundary, a parliamentary constituency has got a boundary, and so on and so forth. Those boundaries, again, are informed and aided by survey. And so, again, it's important to understand that this entire discussion is hinged in the very foundation, which is survey, and allows governance of whatever resources that therefore are under that administrative zone, and of course, key of which is land. And of course, Mr. Moderator, remember that in economics, when we talk about factors of production, land features prominently. And therefore, anything that has got to deal with providing land towards the further exploitation is very important as a foundation. The other aspect that survey comes in again is what I'm calling statutory demarcations. You will all agree with me that a bigger aspect of law is hinged in the concept of jurisdiction. Yeah, to the extent that, for example, even magistrate areas are defined by jurisdiction, and so that jurisdiction, quietly, although it is used generally, it is a very important concept in terms of it is safeguarded by the accuracy of surveys. Yeah, and so if there's a magistrate area of, say, Kololo, and another one, say, of Kamocha, that boundary is very clear, and it can cause technicalities if you don't understand the boundary in the aspect of where a crime was commissioned and which court you have gone to for redress. So again, jurisdiction is a very key issue, and is operationalized by survey. But coming more to the question that I think everyone is interested in hearing is the issue of physical planning and mapping in general. 2025, we would be expecting that much of the globe should be mapped to the detail. Jurisdictions like Europe and the Americas and so on and so forth, this has been substantially done. Yeah, but in a country like ours, we still have challenges with full coverage and mapping of our landed resource. But even with that as a limitation, we know that we've got a town and country planning law, for instance. And it is under that law, and even the Local Government Act, it is very clear that there is a general understanding of settlements. And the general classification of rural and urban has been, is an active notion. But those definitions of what is rural and what is urban is anchored in mapping, is anchored in survey in order to aid physical planning and definitions of those particular zones as settlements. And so, and arising from that, we've got the concept of land use. Yeah. So again, you will not be able to say that, for example, Kololo has been degazetted by KCCA from residential use to mixed use if you don't know and don't have an understanding of the extent of Kololo, isn't it? And so the uses, as we know them, of residential use, agricultural use, industrial use, commercial use, institutional use, and etc., are defined by mapping, which again is put in place by survey and measurement of land. And so if you go to certain well-organized and advanced countries like Singapore, argue it is a very small country and a very rich country, yes, but what I'd like to put across is that every single little inch of Singaporean territory has been given a use that cannot be changed unless by act of parliament. So you cannot wake up today and say, I have got my house, my plot in Nigeria, and so I want to raise chicken tomorrow. No, you cannot do that, because that particular property has got a use. You never get planning permission if it's not consistent with the pre-dictated usage that that property has been put to. So again, that is a very fundamental aspect, and a lot of things arise from that guarantee the orderliness and of a particular settlement, and then of course the growth and what you'd call highest and best use of a particular piece of land or a settlement, a neighborhood, and so on and so forth. And again, coming closer to what I think the community here wants to hear is the aspect of registration. So again, the entire process of survey and whatever complexity we may add to it all comes down to one simple thing. Because land cannot move and you cannot hold it in a pocket, yeah, because it is fixed, yeah, the only thing you can do is move around with documentation, yeah, that's the guarantee that you're referring to and you mean a particular piece of land. And so the ownership and security of tenure, yeah, is guaranteed, among other things, through a process of smooth and accurate measurement and recording and updating of land information. And again, the very first role of registering land is establishing boundaries, measuring extents, and planting beacons, and of course creating maps, and that whole aspect of introduction of that piece of land into the cadastre that I mentioned earlier. So that is what is perhaps the biggest enablement of survey. So it allows you to have, you can move around with a briefcase of titles, but what that really means is that the survey function has allowed you to be able to move around with ownership, yeah, that is transferable without moving the subject matter. So ordinarily, if you wanted to sell a car, I would say, bring it to me, isn't it? I would inspect it and so on and so forth. If I want to buy something, a commodity in the supermarket, I go and pick it. But for land, we transfer and work with documentation. We don't move the particular asset itself. So again, this is guaranteed by the notion, the function, and the science of survey. So issues of tenure security and adjudication are again based on documentation rather than the subject itself although you will also agree with me that there is unregistered land, yeah, and there's also a whole other system by which that is managed, is secured, and is adjudicated. But now we are just talking about a little bit more about registered land and how that enables, and probably how that is superior to non-registration of land itself. Beyond that, there is a notion of valuation. So again, like we mentioned, land is a factor of production. Yeah, so no one holds it for fun. Everyone is holding it for a particular use, and which use is commercial. So the notion of valuation will always occur. But just like a price has got to be for a defined product, you cannot value if the definition of that subject is not very clear. And so again, that is anchored in survey. So survey allows you to say, I am this rich. If you're a company, you have a balance sheet. On your asset side, you have fixed assets, and it could include, say, plot for Acacia Avenue for when we're referring to Uganda Law Society. If you want a value which I'm more than certain you are interested in, it is possible because it is anchored in definition, which is operationalized by land survey. So valuation is for what purpose? It's a host of purposes. Yeah, like I mentioned, number one is for your financial reporting. Number two, it is for your transfer. Number three, it is for your taxation. Yeah, it could be in compliance with state law, it could be in compliance with municipal law, and so on and so forth. But because it's a factor of production, valuation, which is all enabled by there being a reference point, which is also guaranteed by survey, means that a lot of things now begin to become possible because survey has provided that as a foundation. Of late, Mr. Moderator, you've heard us talk about sustainable, resource utilization, and so on and so forth. Again, the whole notion of conservation, be it of natural resources, be it of architecture, be it of anything else that you can think about, is defined by survey. So therefore, your national parks, your forest reserves, your marine parks, your aqua parks, your low-lying areas, your river banks, your lakeshore reserves, and etc., are defined and demarcated by survey. And so the whole conservation aspect is made possible because we are able, using the science of survey, to define what is, what resource is to be put under what particular use. And then, of course, finally, I had talked about extensively around the notion of layering of rights. I talked about leases and licenses and other interests that can be created on the same piece of land. And again, the confidence of third parties or all players in transactions is aided by the ability of there not being any contestation between what is defined as a subject of any transaction. With that, I invite any questions, and I thank you very much for listening in.
Thank you very much, Mr. Tudia Hikayo. First of all, I would like to welcome those members that are just joining us now. Just from the start, if you have any questions for Mr. Tudia Hikayo, I invite you to send in your questions because we shall have him for just a limited period of time. But I think, like many of you can agree with me, that we are glad we began off with him because he's really set the ground for today's yearly training. And from what I got from his elaborate presentation is that thanks to survey, we not only can, for one, define a particular piece of land as regards to the extent of its boundaries. I personally can own land. He talked of the cadastre, where you can go and you can find out the owner of the land, what time they were registered. Even when it comes to the transfer of that land, you can be able to tell the right person to deal with. He's talked about aspects of the various rights that may exist on a particular parcel of land, which I think will be encompassed on by our subsequent speakers. He talked about the various interests that can be registered on a particular piece of land. He's talked about all the territorial issues. He's talked about the valuation. He's talked about the mapping and everything. So Just to start off, we have a question from one Miss Prosi Catherine Bagora. She says, how can we be sure of the accuracy of measurement tools used? Are they periodically calibrated and verified by the National Standards Board? We again welcome more questions. There's another one by Mr. Joseph Kasozi. He's asking, what is the Kalamazoo? I don't know if I even pronounced that right. So maybe for now, Mr. Tuyahikayo, you can begin with those few questions. Thank you.
Yeah, so thank you very much. Yeah, so the question on tools is actually quite a good one. And so in survey, there is a process. And one of the processes as we go out to do or execute a survey is something that we call instrumentation. Now, instrumentation is pretty much what I think is being asked by Prosi as the tools. And so in the stages that precede fieldwork, one of them would be what we would call reconnaissance. So a reconnaissance helps a surveyor just have a good understanding of scope and terrain that they are going to be engaging in. And so things like canopy cover, things like how hilly a place is, things like vegetative cover, things like the weather of that particular time defines quite a lot in coming up with the right instrumentation. So in the past, obviously, there were what you would refer to as manual instruments. And then the challenge with these ones would be, or rather was that you are working without having a control point, yeah? And so I would start physically measuring the way you would say, pick the area of a room like this one. But without taking you through the complexity of the advancement of survey instrumentation, is that the long and short of it is that we are now, thanks to technology, we are now using what we call the global positioning system. So what has happened is that at a global level, every inch of the globe has been given a reference point. And so what surveyors are now working with are instruments that are able to read from the same global positioning system. And therefore, that would mean that with the right instrument that has been calibrated properly, and you're using the right data set, you should be able to get almost 100% the same results, in between different practitioners. And so, yes, it is very key that the instruments of any process would justify or dictate the outcome, and good practitioners there or in Uganda are largely now using GPS, right? But then also, I would just like to mention it to you that unlike legal practice that still has an aspect of state practitioners of the law, survey has been largely, for lack of a better word, privatized. And so most original surveys are done by private surveyors. But like I mentioned earlier, is that all practitioners are governed by a piece of legislation. There's a Surveyor Registration Board, which is put in place by the line minister, which is the Minister of Lands, Housing and Urban Development, and it is the one that is charged with overseeing that the practice of surveyors is good. But then also there are obviously a few challenges with a largely privatized sector. You are unable to police everyone as much as you could, and obviously that's why you have various challenges that are being reported from various quarters around malpractice and other ethical issues that involve surveyors and are causing a lot of trouble in land and therefore causing adjudication challenges. But the long and short of it is that a good practitioner would have up-to-date equipment which will be calibrated from time to time, serviced like any other piece of technology, and of course applied properly given circumstances that one is working in. Number two is a kalamazu is simply refers to a book that, that has got entries, yeah, that entries on transactions on land. The kalamazu was a creation of the manual system of recording land survey, and the idea, of course, here was to also, like in line with what I mentioned under the torrent system, the idea was to protect individuals that attempt or that have made an effort to make changes to the cadastre, and it tries and records everyone who has made an application, and therefore another application could be a variation, say for example a subdivision of land or a change of acreage and so on and so forth. So it's a general register, a reference book that shows all ongoing transactions and to what end and what processes that they have reached. I don't know if there's any other question that has come through on the thread.
I think in the interest of time, we shall take two more. There are two questions that are a bit similar. One by, my apologies, I don't know if it's a Mrs. Doreen Nangwala or, yes, Mrs. Doreen Nangwala. She says, how possible is it to open boundaries and create fresh deed prints, overlaying already existing land, having a different description? In brackets, she says, particularly plot numbers. She goes ahead to say this is an ongoing vice, and one wonders how two titles can exist over the same land, but with different plot numbers. How is this then even sanctioned? Her question is similar to, in a way, to Mr. Henry Barwani Magino's question. He says, of course, introduces himself and says, why does the land registration system allow two freehold titles on the same piece of land and each owned by different registered proprietors? I'm not referring to a lease or registered land. This type of ownership for allowed creates confusion and undermines the integrity of land registration. I think we shall have those two, and also maybe just to relate it in a way to the to the torrent system. Yes. When you earlier on were talking about the torrent system, you said it was supposed to be a one-stop center.
Yes.
Of if I'm going to buy land, I'm supposed to check on the registrar, and I'll be able to know who is the particular owner of this land, what encompasses, if any, are on this piece of land. But from these questions, as you may see, it has become a bit complicated that the torrent system may not be just a one-stop center. So how, if any, do you deal with such a situation? So I would allow you to respond to those questions.
Okay, yeah, thank you very much. So again, we don't live in an utopic environment, yeah? And number two, every system is created by individuals, right? And the general principle around systems is that garbage in, garbage what? Garbage out. But that does not defeat the essence of the system itself. And the creators of these systems make assumptions that there is a certain level of ethic that will be applied to, first of all, the custodians, and then secondly, the users. So by definition of what torrents is, it does not go ahead to also tell you how it can be abused. Yeah? But the system is intact, yeah? And it tells you what it can do and what it cannot do. Number two is that obviously the system in itself will largely be a reflection of its environment. And like I mentioned earlier, for example, surveys and mapping as a directorate for very many years was domiciled in Entebbe. Yeah, Entebbe is where the entire country, all the maps of survey and mapping across the country were domiciled in Entebbe. Until around 2010, I think the World Bank project that came through to help us develop an LIS, which is a land information system, And then later created MZOs, what you're calling, which are ministerial zone offices, which will try to decentralize the land registries to bring them closer to the people, so to speak, is that everyone had got to, your job had got to terminate and go through Entebbe. Now, you think about the traffic that what we are facing, even in the MZOs. Some of them are very busy, like Wakiso, Mukono, and so on and so forth. It would mean that there's a lot of load on how the manual system could have worked efficiently, even without fraud on the part of either the users or the custodians or the applicants. I cannot tell. But essentially, what you're seeing is not failure of the torrent system as designed, or the Kalamazoo system, or the cadastre, but it is either negligence or fraud or anything else that you can occasion to on individuals, or even what you call probably innocent mistake, if it's anything like that, that allows people then to come using all sorts of source documentation that is irregular to to mislead the custodians of these systems, to misinform and therefore create wrong records. So the scenarios that are being talked about by Henry and Doreen, yes, they do happen, and essentially, if it were, if the information, let me just take you through in a quick way, a simple application for bringing land to the RTA for the very first time. So I come from Sembabule. It is a district. The land is governed by a district land board. I have an area land committee. I commission a surveyor to come and measure my land. He comes, does reconnaissance, does a survey. In the course of the survey, I consult my area LC and all my neighbors. And then the area land committee is informed. They come and sign on my forms. The forms are completed properly. I then apply for a lease or a grant of freehold from my district land board. The land board sits and grants me a minute, giving me terms and conditions on usage, on any dues payable. I pay those dues. The survey is completed and it is taken to my ministerial zone for titling. Now, in the past, that would be done. There would be a sheet created, it would be kept, and I would also keep my title. Now, if someone in my absence, again, fictitiously goes on my piece of land, or rather works even with my surveyor, and they decide to create another 50 acres out of my 100 on the same piece of land, and I go through the same process, I hoodwink the area land committee to also sign for me, I hoodwink the area LC to sign for me, I mislead the district land board to give me a grant. I go do my payments actually. I go to the MZO, and remember these are not, it's not a digitized environment. They will create it because the MZO personnel that does not have a requirement to come on ground. They presuppose that the area land committee has done the right job, and the district land board and plan at the district have also done the right job, isn't it? So they would give me a title. But the coordinates of those titles, the geographical coordinates, are falling within the title that was created first. You get it? So under the law, under the first in, first out principle, it is very clear that the title that was created later would now collapse if challenged at a particular point in time. Isn't it? So that is the principle. And of course, the RTA provides for a procedure for cancellation, which I think we are all aware of, but it does not mean that the law in itself cannot be broken in a way to create the embarrassments that are being talked about. But in advanced societies where you have less tendencies of such practices, these principles are aided by technology, and LIS now are working perfectly, and are giving are actually about to, in some countries, even the role of surveyors is about to get extinguished. It's like having prisons in society that has no people who commit crimes. So we start closing them down and changing youth, like it's happening in some countries in Europe. So again, because it's an exhaustive trade, yeah, to a certain extent, especially the rudimentary aspects of mapping or original mapping. You find that now we are now moving into other aspects of practice run or original survey, because at some point it will actually get, it's a finite role which will get, fully executed at some point. I don't know that you want to allow a question from...
Yes, briefly allow my senior.
Yeah, thank you for accommodating me, Mr. Moderator. Now, you find that a title created out of an old survey measures an area of a whole number, point decimals and microdecimals, which would depict accuracy, in the survey carried out, although it was manual. Somebody goes to sell that land, and when the purchaser is doing a due diligence and opening up, boundary opening is carried out, you find that, for example, land which was measuring 20.5923 hectares is less by almost an hectare because of your new instruments. Is that accurate, or there is a trick?
Yeah, so interesting, yeah. The response to that is that generally the principle of advancement and adaptation to technology is that it is better and more accurate. And so, simply put, in the absence of incompetence of a particular initial expert who did that particular role, the presumption would be, and it generally is the case, that instrumentation is getting better and better at giving more accurate and precise results. The other thing is that that I would like to say is that there's always going to be some challenges when it comes to reconciliation of data that is got maybe 20, 30 years apart. But the general principle would be that even if there is a variation in acreage, there should not be a variation in physical extent. I don't know that that makes sense. If we are measuring the same piece of land, say let's say this table we are working on, all right? If I did this survey in 1962, and I surveyed it, and I put boundary pillars and demarcations that still define the same piece of land now, yeah? Even if there is a change in acreage now, that change of acreage does not mean and amount into a change and redemarcation of the what? Of the land. Meaning no land has been lost, no land has been gained. And whichever way that new figure goes, the adaptation is because it is based on, one, a competent expert, and number two, good equipment for that matter. So any cartographer or anyone in charge of a registry, if you went there now, so for example, you're updating a lease, yeah, a lease has expired, and you're doing you are renewing. A good cartographer, and I think it is a dictate of the practice code, it would say, go back and confirm to me that what you're trying to extend, which stood for 99 years till yesterday or tomorrow, is actually still the same what? The same subject. And we also use it as an opportunity, because of course we are a poor country, we cannot do what we call mass survey, where we say the entire country, all of you apply, the country is going, oh, we are forcing all of you to measure your land. We can't do that. But we take the opportunity where you subject yourself to a process that is statutory for us to say, okay, you contribute this data for us, get us the information that shows that that subject is still what it is. So to respond to that in a nutshell would have been that whereas you can challenge surveyors by competence, surveyors by genuine mistake while in the field, or instrumentation old and new, whether we are advancing or not, whatever that discussion is, it should not change. Should not change what I thought was the full extent of my land, and the boundary should not move simply because the instrument has changed. That would be my response to that. I don't know that there are any other question, but I think they're now around the same concept.
I think in the interest of time, that will be all. We thank you so much, Mr. Tujahikayo. We have really, I think the membership would agree with me, we have really benefited from your presentation and also for having laid foundation for today's CLD training. So thank you very much, sir. Next, in the interest of time, we shall have our next speaker. That is Mrs. Bernadette Bachide Nachimbugwe. She's going to be presenting a topic, a comprehensive review of the land tenure systems and various rights that accrue. Briefly about our speaker. She's a social justice lawyer, and currently she's a consultant specializing in access to justice, human rights, land governance, conflict and dispute management, gender justice, institutional governance. She has worked in the civil society sector for over 15 years. She is actively involved in research and law reform of several laws, such as the succession amendment processes, currently the hot topic, the marriage bill, to mention but a few. She's also the honorable secretary of the Foundation for Human Rights Initiative Board, and she's also formerly a board member of several institutions, such as the Justice Centers Uganda, FIDA Uganda, just to mention but a few. So allow me welcome Ms. Bernadette Bachide Nachimbugwe to make a presentation. Thank you.
Thank you. Assalamu alaikum. Good morning to everyone who's joined us in this discussion. Thank you, Law Society, because when it comes to land-related matters, I think those are the highest number of cases in courts of law currently. The previous speaker has actually made my work easy, so I'll go straight to the legal. When we talk about land tenure and the rights that accrue, the previous speaker mentioned that you might have a parcel of land, but with so many interests. So I think it's incumbent upon us as lawyers, as practicing advocates, to ensure that we understand and appreciate the different rights of all the different interests that are on this piece of land before you proceed to advise or represent the individual. So when we look at the policy and legal framework, I'll not highlight a lot because it was mentioned, but we have several laws, policies. Of course, we have the National Land Policy, which is currently under review. We have oil and gas, the National Land Use Policy. We have the Gender Strategy for the implementation of the Land Policy, ETC. But we also have the law applicable, which is basically the Constitution, which is the foundation and mentions the different tenures under Article 237. We have the Land Act, which is currently Cap 236, and other laws in relation to the different tenures, the Succession Act, because as we're all aware, when we talk about land ownership, you can either buy it, or you can receive it, or you can get it as a gift inter vivas, or you can even sell. So basically, those are different types of ways someone can own land. We have the different regulations. We have the land regulations, physical planning standards and guidelines, etc. However, we need to take note that the Constitution provides for general rights. I think I'm not on the same page with please, could we go to the, sorry, because of time, but we have the general rights, which basically vest land in the citizens of Uganda. We have Article 26, which specifically entitles everyone to own property, and in most cases we look at we look at land. Then also we have issues related to privacy. We have a right to fair hearing in case your rights are violated, and other rights. I'd like us to proceed to the next slide, please, and then the next slide. Members, you'll receive these notes, so you'll look through the rights. So what is land tenure? Land tenure basically refers to the manner in which land is owned. How do you own this parcel of land? How did you occupy it? The previous speaker said most of us use land, but we actually don't have registered, we've not registered our interests on this land. And based on my experience, majority of the women who use land actually use the land, but do not own it. And then also, land tenure refers to the way in which we dispose we dispose our interests within this land. Then tenure security. For you to have the land tenure, but we need security of tenure. And basically, when you talk about tenure security, this refers to the assurance and protection of land rights for individuals and communities. So when we talk about what is encompassed in tenure security, I would like us to recognize that we have a legal framework, legal recognition of land rights. Where are they provided for? In the different laws that we have mentioned. So it's incumbent upon us as lawyers to know that all these rights are actually legislated. So it's important that we have a legal framework as a country which exists. We have the Constitution, we have the Land Act that provides for the different forms of tenures and the different rights of individuals. But in addition to, the previous speaker said that it is the duty of the state to provide for these rights, but to ensure that they are protected. Protection, we have the right to acquire property, but at the same time, for me to secure this right through registration, there's the RTA, which will enable me to conduct the different formalities to register my interest. But it is also important for me that if my right to this land is violated, I'm able to seek redress in a court of law, but also I need some form of protection so that I'm not evicted by anyone at any time. Then non-discrimination. Now, all of us have equal rights. We're not above the law. But now this also refers to especially women. From my experience, especially in the women's sector, we've realized that women have been left out a lot. And I think courts have stood with us. I think there have been decisions where there is recognition of the contribution women are making in relation to land, but also they're also taking, there's also, what should I call it? There is also recognition of the non-financial contributions that women are making to this land. But also, if I'm married and I'm a housewife, honestly, I think I have some form of rights over this land. But there's also been a lot of discrimination when it comes to inheritance. Most of the land is bequeathed to the male survivors, but when it comes to the daughters, wives, we are left out. So this also provides that removes my security over this land. Then, of course, the other element is that there should be a duration and transferability of land rights. There should be a procedure or process that enables me to actually transfer these rights, which are really covered by the different laws. And then definitely access to dispute resolution mechanisms. Personally, there's so many structures. We have the judicial, we have decisions that are passed by different courts. But unfortunately, we have also currently, we have other, is it the district monitoring committee? We have the RDC before a court judgment is actually is implemented. It is difficult for a Ugandan, especially the poor. You and I might know what to do, but we look at the majority of Ugandans who have property which is registered in their names but do not understand the procedures, and they've gone to court. The court order is in their favor, but in terms of execution, you still have to go to another party. So so basically, those are the challenges. And then we also have, let's go to the next slide, which really talks about the history of land tenure systems during the pre-colonial period. land was basically communal. We had also clan tenure systems, but we also had the nomadic tenure systems where land was basically used for grazing. Next slide, please. Then when, with the introduction of, during the colonial period, that was when the Buganda Agreement was signed, and this was basically between the chiefs of Buganda and also some areas in Toro, and there were different laws basically to ensure that there's some form of protection, especially in relation to the interest on the different plots of land. Let's go to the next slide. I think members will read through this. I implore members to read through through these slides. Next presentation, next slide. Let's proceed. The next one. Then we have the land reform decree that was during the Amin era, where all land, private land, was there was basically an overhaul of the tenure systems, and all land was declared public land, but now this was also repealed. So basically this is for information purposes. So let's go to the next slide, please, which provides for the different, so 1995, yes. So the next slide, please. So the land tenure systems, currently under Article 237, Section 2 and 3 of the Land Act, provide for the different tenure systems, which is customary, freehold, milo, and leasehold. Next slide, please. Next slide, please. So we'll start with customary tenure, which is provided under Section 3.1. So basically, the key characteristics is that this is applicable to a specific area of land, and it is also specific to a certain class of people. So it is, in most cases, owned communally or jointly by a particular group of people who register communal land ownership over this land. So what are the rights they are under? As I've mentioned, one of the right is that the land is owned by the community, but in accordance with their customs and norms and practices of that community. Secondly, it is definitely governed by the rules and practices accepted by that community. So basically, if you're a Muganda and you go to a Choli region and you want to acquire some land within one of the areas, especially customary tenure, you'll definitely have to go through the customs because most of this land is not registered. So it is incumbent upon you to actually understand who are the owners of this land. Is it even registered? And so you'll have to go to the different cultural leaders to actually access and also express your interest. However, despite the land being governed by the rules and practices, it is important that it is not discriminatory against women, children, and persons with disability. Then also, the communal land ownership is usually, it is in the form of registration of communal land associations, and these communal land associations are the ones that apply for a certificate of ownership. However, because the land of late, I think we've realized that the population has grown. So there have been so many subdivisions. We don't have communal land owned by a certain culture. So there have been a lot of subdivisions, and land has been transferred to individuals, to families, even some traditional institutions. So this is one of the rights that, yeah, you can register it as a communal land association, but because of subdivisions, people have been able to access, to apply for certificates of ownership as individuals. Definitely this land is owned in perpetuity, and I think I mentioned about the certificate of customary ownership, which is acquired from the District Land Board, and it is also conclusive evidence to show that you have an interest on this tenure. The previous speaker said you might have an interest, but is it registered? So for customary tenure, someone can apply for a certificate of customary ownership. Most of the people on customary tenure actually only have user rights, and this applies also to women. And unfortunately, this land is not surveyed, and majority, but there's currently there's a project by the Ministry of Lands that has been trying to ensure that CCOs are given to different stakeholders on customary tenure due to the number of evictions, the increase in arbitrary evictions. Next slide, please. So the other form of tenure is freehold, and this is land which is registered and owned in perpetuity. As you can see, that the rights they are under is that someone can apply for a certificate of title, which is proof of evidence that they own that land. Of course, the land is held in perpetuity, and the owner, basically the one who holds the title, can use the land in whatever way they please. However, they should not violate any provisions of the law. Sometimes freehold land has bona fide or lawful occupants, and I think we'll discuss who qualify as bona fide and lawful occupants, because I think that number has also increased of late, and that's why we have mass evictions, but also an increase in the number of cases in court. The owner has, as I mentioned, the person who has the certificate of title has the right to use it in any manner, can transfer it, can transact it, and we're going to discuss, the next speakers are going to talk about mortgaging, can subdivide it. Basically, you have control over this land. And they can also dispose of it in any manner, either by selling it or even as a gift inter vivas or by will. However, we've realized that there's an increase of issuing certificates of titles to non-Ugandans. That is subject for discussion at another day, so I wouldn't want to discuss that. So Milo tenure is another form of tenure. This was definitely created under the Buganda Agreement. I'll emphasize this a lot because most of the land under Milo was registered. And then there were so many subdivisions over the year, which has created so many small parcels, and all these parcels have titles. Now we had official Milo, which was granted to the Buganda local government, and definitely it was transferred to the person who took over office. But these were abolished during 1967, but reinstated under the Restoration of Traditional Rulers' Assets Act. Next slide, please. And then we have the private Milo, which was granted to chiefs, private landowners, and that falls within the 8,000 square miles. And definitely there've also been so many subdivisions due to inheritance, selling, and all that. Now, the challenge is under Milo is there's so many underlying rights. There's so many people with so many interests on the same piece of land. So you might have Bakide Bernadette as the registered landlord, but when it comes to the tenants, I have several tenants on the same piece of land and they actually have titles. So that is where there's still a lot of conflict. What are the rights of landlords? What are the rights of tenants? Next slide, please. Next slide, please. Next slide. Okay, thank you. So basically, one of the rights is that this land is held in perpetuity. Ownership of the land by Milo owner is separated from ownership of developments on land, especially by a lawful and bona fide occupant. So I might have the right to sell, mortgage, but it is subject to the existing bona fide and occupants on the land. So basically, that's where there's been a lot of conflict, because the law provides that as a landlord, I'm supposed to receive rent, or let's say ground rent. It's actually ground rent, but it's not sufficient. Most landlords are complaining that the money is not sufficient. I mean, you're using my land, you're earning millions from it as a lawful or bona fide occupant, but me as the landlord, I'm not able to use it the way and I'm not gaining from it. So that's where there's been a lot of conflict. But we also have people who have claimed that they are actually lawful tenants. So who is a lawful occupant? So this is provided under Section 29. So a lawful occupant is that one who has paid rent or ground rent. That was who entered this land and started paying rent under the Busulu and Mvujo law, or under the Uncle and Toro land tenant laws, and has receipts from the predecessors or from the person from whom they purchased this land, the landlord. However, a lawful occupant is also that one who may occupy, who acquired permission from the landowner and also has an agreement that shows that they acquired, that they bought this land from the landlord. Then we have customary tenants on former public land who was no compensated by the landowner at the time of getting the leasehold, etc. So that is a lawful occupant. However, we also have bona fide occupants, and those are people who settled on land before the Constitution, which was 1983, and they've utilized it, developed it, unchallenged by the landlord for over 12 years. And then also, or if not, they were settled on the land by the government during the resettlement plans, like those who are in Bududa, etc. Now that's where the conflict lies. We have individuals, next slide please. We have individuals who don't fall under those two categories, but have actually stayed on that land for over 12 years, and the landlord has kept silent. So that's where we seriously need to think through. Maybe this is a law society discussion. There are ongoing processes within the ministry to see how these laws are reviewed to ensure that all the interests on this land, especially Milo, are protected. So what are the rights and roles and responsibilities for landlords and tenants? So the tenant enjoys the right of occupancy and use, but the landlord has the right to, owns the land, so that is their right. The tenant has an obligation to pay the annual ground rent, which is Busulu, or ground, which is determined by the district land boards. And because the law clearly provides that non-payment can lead to eviction. So, but it's also the landlord's obligation to receive that ground rent. However, right now, I mentioned it earlier, the Busulu is so low, so even landlords are not receiving the money. The money has been taken to sub-counties who are also rejecting it, because they're also saying, you know, this is a private matter between individuals, but also how do we keep this money to prevent it from getting lost within the local government. The other right is that the tenant has the right to enter into any transaction, can assign, can sublet, can pledge or create third-party rights, as was alluded to earlier. But this has to be subject to approval of the registered owner. Question is, how many have done that? Most of the land transactions, landowners are not even known. The other issue is that some landowners actually maybe inheriting the property, but the land is still registered in the names of their great-grandparents. So there are also issues in that area. So the other right is where the tenant by occupancy wishes to sell, the first option should be given to the landowner and vice versa. However, this has not worked out because it's working out for some parties, but majority of the clients we have received, all the cases have mediated. It's basically how deep is your pocket principle applying currently, and majority of Ugandans do not have enough money. Then of course, then the registered owner, they can by mutual agreement subdivide the land after they've paid the landowner some amount of money, and yeah, can then secures a title over that land. Next slide, please. So the tenant also has the right to apply for consent to be issued a certificate of occupancy over that land that he or she occupies from the registered owner, and the owner is actually supposed to grant that consent. The other issue is that the tenant has an obligation not to leave the land unattended to for 3 years. Otherwise, their tenancy will lapse. Next slide, please. So leasehold, I'll look through that briefly. Basically, we have a landlord who is the lessor who grants another person called a tenant or lessee for a specific period of time in return of payment of rent. So we have private leases, we have public leases, and then also we have mining and ranching leases, which are granted by the government. So basically, the rights, lessee can sub-grant. There's exclusive user rights. In case of breach, it can be terminated. And also, non-citizens cannot be granted a lease for more than 99 years. So basically, those are the rights that accrue under the different tenures. And in terms of public land, I think that one will be, you can read it on your own. And thank you for listening to me.
Thank you, Ms. Bernadette Bachi-Denachimbogwe, for that presentation. I would like to encourage our membership, just in case you have any questions, to send them through. Maybe to start off, there is an interesting comment. It's not a question, a comment by Mr. Benedict Arenaito. He says, hello, Uganda land tenure systems need to be reviewed. So what would be your take on that? Thank you.
I think it's not a question. It's actually, I think, a proposal. But my personal view is that if we already have registered interest on this land, how will we review, how will we protect and ensure that these registered interests, their rights are not taken? Because that is a serious, I think that, and it mostly applies to the Milo, Busulu, and Busulu issues. Milo landlord, Chibanja holders. I think that's where the biggest problem lies. Because you have a number of people with different interests on the same piece of land, and the land is registered in either family or individual. So I think this one I think is a subject for further and a lot of scrutiny. I cannot have an answer, but I totally agree with that. But we need to take note. What about those interests that are already registered? How are we going to ensure that they are not affected by this review?
Thank you. There was yes, there's another question by Mr. Akram Dennis of what is the process of converting leasehold, especially KCA, to private ownership. But I think if you can, maybe throw some light on that. But there's also another one by an anonymous attendee asking, how do you categorize condominium titles? And there is another one asking, one Miss Cindy Atukunda asking for a distinction between lawful and bona fide occupant. So if you can take on any of those.
Thank you. I think when it comes to condominium titles, that is, they can fall on any form of land, apart from, I think, customary, unless it is registered or it was converted into freehold. So, and I think that's what the previous speaker mentioned, that you might have several interests over the same piece of land. You know, you might have a freehold, like the current structure in which we are in, Law Society. This is a property, but you might have the freehold title, but you also have a leasehold on the same piece of land. Then you have even a sublease on the same piece of land. So when it comes to condominium titles, they can fall on any form of tenure, except customary. Lawful and bona fide occupant, I think I tried to explain that. Cindy, I think you look at my presentation. I think I alluded to that. How come? Or the process of converting leasehold, I think I'll respond to that later because of time. because we now have a very interesting session on mortgages. So I'll I would humbly request that if we have time, I can respond to that, or I can even give an answer through the chat.
Actually, we have a few minutes to spare, so maybe you can make do with those. Maybe just to add, one question from my end was, during your presentation, you talked about, I think, the most prevalent discrimination about women and men when it comes to the ownership rights. I think even you touched a bit about the issues of succession. But during your presentation as well, an interesting aspect emerged to the issue of the landlords when it comes to the Busulu. Because I would imagine someone owning land, then someone occupying his land but is not paying sufficient compensation for the said use. So is there a policy to address such disparities? Thank you.
Thank you. Currently, in terms of the amount to be paid as busulu or ground rent, it was determined by the different districts, because the value of land within Kololo cannot be the same value of land in Wakiso, for example. The Ministry of Lands came up with a resolve that different districts should come up with different rates in terms of ground rent. But the challenge still exists, especially where the landowner is not able to access or use that land. The money that they are receiving right now, that's why you see there are rampant evictions. The money that is being received, the ground rate that is being received, is not sufficient. And that's where the landlords are saying, okay, Mwegure, can you compensate me so that I can issue you with a title? We subdivide the land, you get your title, and I move out of that deal. You know? So that is the discussion that is happening right currently, because we've realized that there are so many people, the land has been subdivided so much, especially by Chibanja, by tenants. Even local leaders have been engaged in selling parcels of land. And of course, in the absence of the landlord just realizes, and because the tenants also they have the right to actually subdivide the land and sell it off. But the challenge is that all these people who are buying this land, their interest, they only have agreements, and agreements which are not registered. So in terms of protecting these interests, we need to, that's why I think someone mentioned that we need to review the entire system, because there are so many overlapping rights over so many big chunks of land, and the landlords are not satisfied with the amounts they are receiving. Someone might have a farm, a chibanja of 3 acres, and earns close to 2 or 3 million per month from maybe the coffee. But the landlord is getting annual ground rate of 45,000. Even actually, the Constitution, I think, provides the Land Act provides for 1,000 shillings. However, because the 1,000 was not sufficient, Ministry of Lands issued instructions that the different district land boards should come up with a certain amount that is applied within the different districts. So you might find that ground rent in Wakiso might be 35,000 shillings. You know, so those are the challenges that we need to seriously think through as lawyers, but also advise the ministers, because there are so many issues when it comes to Milo land, even freehold. Freehold land also has squatters, you know. So that is a discussion which we cannot conclude today, but it requires a lot of review, but also to protect the registered interest. The landlords are saying, I have a title, but I'm not earning from it. So the procedure right now is, how deep is your pocket? How much money do you have to pay me? I grant you your title, and you deal with it as you wish. But now we are looking at fraudsters. You have no paperwork that shows how you acquired this land. A local council leader has sold off the land, has no agreement, nothing. And then the landlord will say, I do not know you. Thus, leading to an eviction.
Thank you so much, Ms. Bernadette Bachidenachembogwe. Thank you for your presentation. There is, I think, Mr. Seranga Moses Paul. Yes, the speakers have made it clear the soft copies of these presentations will be made available to you after, I think, the training. So allow me to, next, we are going into a presentation by Ms. Ashaba Sharon Mwebaze. She's going to talk about the role of lawyers in protecting clients' interests in mortgage agreements. She's going to give her perspective as in-house counsel. Briefly about Ms. Ashaba Sharon Mwebaze. She's an advocate of the High Court of Uganda. She has her qualifications. She has an ordinary diploma in law. She has a Bachelor of Laws degree. She has a postgraduate in legal practice. She has a master's degree in business administration, and she's currently pursuing her studies to become a chartered secretary. Right now, she's working with as in-house counsel with Centenary Rural Development Bank. She's the legal manager. And she has a wide experience. She's been in the banking sector for 12 years, 8 of which she has spent with Centenary Rural Development Bank, 4 of which she's spent with the Finance Trust Bank. She began her career with the RSB, and she's also a board chair of Destiny Microfinance Limited. So, with that introduction, I would like to welcome our speaker to give a presentation. Thank you.
Okay, thank you so much, moderator. As put to you, my name is Shaba. I am a practicing advocate, but I practice as an in-house lawyer working with Centenary Bank. My purpose here is very simple. I know it's an interesting topic, as mentioned earlier, but I will be looking at the role of a lawyer in protecting their client's interest in mortgage agreements. My presentation is largely practice. What do we do as in-house lawyers? My prayer and appeal is to each one of us to allow ourselves to unlearn, to learn, and even relearn some of the things that we know about the mortgage law, the mortgage practice, how financial institutions are doing this, and what affects our clients. Because as for me, an in-house lawyer, my client is the bank. My client is the people that deposit with us money that we do on lending to customers to meet their needs. My brief overview is that I'm going to just define what a mortgage is and what it means. And then I'll briefly also look at the law applicable in the mortgage process. So many laws have been talked about. I'll not dwell so much on that. And then I'll delve into the process of mortgaging property. What do we do as in-house lawyers and as financial institutions? I'll also be looking at now my role, me, the in-house lawyer. When I sit in the bank, what do I do in supporting and ensuring that my clients' interests are protected in this mortgage process? And then I'll briefly take you through some of the legal documentation that we work with in this process. And then I will look at the rights and duties of either party in a mortgage agreement. And then I'll give an overview or some detail a bit of the foreclosure process. What happens when a customer fails to pay money that was advanced to them as an in-house lawyer? And then I will conclude. My colleague, Senior James, will look at the perspective of a practitioner, and then we shall dialogue after that. Now, in defining what a mortgage is, some of us use a lot of Google, but I found the definition of Google a bit blunt, because for it was saying that this is an agreement between you and the lender that gives the lender the right to take your property, which I do not agree with, because you have failed to pay the loan. I will put it clear that financial institutions are not interested in customers' property. Our interest is ensuring that the money we have lent out is returned to the bank or to the financial institution so that someone else can take it and borrow and be able to develop themselves. The dictionary was a bit fair because it agrees with what the Ugandan law defines a mortgage agreement to be. And it defines it clearly as a legal agreement where a bank or a similar organization lends money to buy a house or land, and that house in itself is a security for this loan. Now, I will take you through what the Mortgage Act defines a mortgage to be. And for it, it actually expounds on what the dictionary says it, because a mortgage is a charge, it's a lien that you who has an interest in land you create to secure repayment of a debt or to perform an obligation under a mortgage agreement. Now, the Act actually expounded, because for it, it defines it as a charge that you, the owner of the land, the mortgagor, you create on your property to secure repayment of a loan that has been advanced to you as by the lender that has advanced this money to you. So our act, the Mortgage Act, is very expound on and explaining what a mortgage agreement is, because when we lend money, it is not specifically for customers to go out there and either buy land or build a house. Why we call it a mortgage agreement? Because you have borrowed money. It could be for business, it could be for whatever it is that you need the money for. But when does it become a mortgage? It becomes a mortgage when you give us landed property as security. Next slide, please. Now, this definition clearly puts it to us that as people who hold interest in land, so the first thing we need to recognize is that you must have that land, or you have someone who has land that can give you their interest in the land to bring to the bank to be able to borrow money. Now, this largely lies with financial institutions because, number one, we are regulated. Number two, we are into the business of lending money. That's our core business. And lately, we've seen so many of our money lenders as well. Thank our country, Uganda, they are now also being regulated. So it's basically an interest, a charge that you create as an owner of land, because you have a need, you have a situation, you need money that you cannot access, but there's someone willing to lay a hand, to extend a hand to you to be able to access money. But because you have your property, you come to this lender and express your interest to access money. So the bank will access the money to you, will advance the money to you, but will take your property as security. Next slide, please. Now, briefly, we can all see the laws that are applying to our mortgage processes. And what I have laid down is a bit different from what the earlier speaker laid down, because for us now we are zeroing down to the mortgage law. And as mentioned, the Mortgage Act is the primary law with its regulations. And of course, we have the Financial Institutions Act, because anyone into the business of lending money must be regulated. Then we also have the Tier 4 Microfinance Institutions Act and Mortgage Lenders Act, and as well as the Bank of Uganda Financial Consumer Protection Guidelines. These guidelines were brought into practice to enable our customers know their rights. And that's a very interesting one. But that's it with the law. Of course, the obvious ones are the Land Act, the RTA, and the Constitution, but as well as the case law, because most of the laws that apply stem from case law, what has been decided, what scenarios have come up that have spoken into what the law has become that governs mortgages. Excuse me. My next discussion is on the process itself. Now, as lenders, when we go out to look for money for customers, we have a process that we follow. It's very definite, and this is laid down, or it is informed by the law, the regulation, the business principles that we work with, and also best industry practice. We do not do processes or procedures that are outside the law. We are cautious to make sure that whatever we are doing is as per the law. It is as per regulation. And also best practice, because we must be seen to remain relevant. The market has so many financial institutions, and we have to see that whatever we do protects our customers as well as our client. So I am too arm-legged because I have an interest to protect two people. That is my client, who is my employer, as well as the customer who borrows, or the customer who saves money with the bank. Now, when customers approach us, we have an obligation. When you come to us that you want money, and most definitely when you come to us, you put in an application. There are no circumstances under which we have lent money where a customer did not need the money. We know there are those situations or those cases that have gone to court, and the customer claims that they did not apply for the money. I will stop that at this point. We'll engage much later about that. But what am I trying to say? That there is a process that we follow. And this process is called the underwriting process. It's basically an appraisal process to assess your eligibility as a borrower. And in that assessment, we must ensure that whatever we are assessing you is wholesome. And this is governed by the 5 C's of lending. Currently, they have evolved to 6 C's. Now, the 5, if you can go to the next slide, the initial 5 C's characterized character, capacity, capital, collateral, condition, and eventually the 6th has become credit score. When we are lending money to you, we have to know you. We may not know you because some of our customers are coming to us for the first time. For those we have been with, our repeat borrowers, there is a history that we have made together. So in a way, we know your behavior, we know your reputation, we know your abilities, we know your willingness to pay. So character is very critical. And this character speaks to your credit history. How have your repayment patterns been? If you've been borrowing, for example, from Centenary Bank, and right now you want to go to another financial institution to lend you money, the financial institution, the new one you're going to, is interested in knowing how have you been repaying your loan or loans in Centenary Bank. Now, this speaks to the 6th C that came up, which is the credit score. I'll speak to that later. Let me get to the capacity. Now, the capacity assesses your ability as a borrower to repay the loan. Here we are looking at your incomes, your cash flows, your financial stability. Because when you come to us to borrow money, if some of you have come to us to borrow, we ask for bank statements. And we want a minimum of 6 months. How have your cash flows been? How has been your financial behavior in you being able to access money from the bank? But this is also seen in twofold. What is your legal capacity to borrow? Are you in the right state to access money? Are you an infant? And so many other things. Then we also look at your capital. Now, this is your buffer, your financial resources, your assets, your savings, your investments. Because as lenders, we do not borrow or lend money, for startups You come to us, I have a dream. In fact, I dreamt last night that I had a big mansion and I've come to Centenary Bank. I want to borrow money to build this mansion. We're saying no. We must know, how are you able to? In fact, if you come to us to borrow money to build a house or buy land, we want a particular percentage of your contribution, because we need to be sure that you have the financial muscle to be able to repay the loan. And then we look at collateral, which is the center of our discussion today. It is this asset that you're going to give to us, the security. Because for us to be able to lend you money, I know we have unsecured facilities, but this is not the reason why we're here. We're here because we're interested in secured facilities and secured by landed property. We have to know, what kind of property do you have that you're giving to us? Is it registered land? Is it unregistered land? Is it customary land? And of course, every financial institution has its policies that it follows in respect to each kind of land each kind of interest of land that you have. Now, I will go to conditions. Now, we look at the different conditions surrounding your ability to borrow. They involve external factors that may impact you, not to be able to pay, the economic conditions that we are in, the different industries. I want to believe some of you vividly remember when we were hit by COVID, what happened. People were unable to pay because of the economic instability and all that we were going through. People were not able to work. So as financial institutions and with our regulator, we sit down to try and understand our customers' situations. And this is also twofold. We look at what has been approved. For me as the legal person where I sit, what has been approved by management? What conditions have been put there for you? Have they been fulfilled or not? And then I go to the credit score. This is an interesting one because before, some years back, financial institutions were not able to access history that speaks to the creditworthiness of our customers. So many customers would take advantage of us. Because you do not know how I have behaved in the other institution, you come to me and trust you. Everyone who wants money, everyone who wants to borrow is a saint because they want to access money. But you will not know what happened, where they were. In fact, some of you, or some of us, or some of our customers are borrowing from money lenders, and we are not being able to access information with the money lenders of how you have behaved. And very soon I know that the law is going to have these money lenders also submit information to the CRBs. So this helps lenders to assess the borrower's credit worthiness, to predict the likelihood, because your trend, your behavior communicates your ability or your character and intention when it comes to repaying loans. And like I intimated earlier, what we lend is not necessarily financial institutions' money. It is public funds. But because we are into the business, we want to earn profit and also access funds to you to be able to develop yourself, to grow your business. It's important that we work together to see that both parties benefit. We have so many CRB companies that have been licensed by Bank of Uganda, and I want to let each one of us know that if you have approached a bank or a financial institution, whatever it is, your information is seated somewhere. In fact, lately, when you're a customer and you step into another financial institution to borrow, I get a trigger, I get a notification. So you find me calling you and asking you, why are you going there? How much money do you want? I can give you an additional loan. Yes, because we're into business and the players are many. So that is what the credit score has enabled us to do. And this is our whole 360 degrees appraisal process. Now, we don't work in isolation. This is majorly done by our credit teams, both at our branches and also at head office. They do this assessment, they do the due diligence, they do all that needs to be done by the foot soldiers. And then when the whole process is completed, at that level, it now drops into the legal space. Next slide. Now, what is my role as a lawyer? As some of you may be aware, we are majorly a support function. We support the teams that go out, the business teams that go out to find the business, but yet very pivotal in decision making. Very, very pivotal, because where I sit as a lawyer, if I have not reviewed a file and advised that this file is okay for disbursement, that money will not come to your account. Now, our major role is focused on managing the legal risks involved in the lending. But we're very cognizant and mindful that we are into business. And gone are the days where we would just be showstoppers as far as business is concerned. And now we're acting as roadblocks. Why? Because we have to make sure our clients are protected. But at the same time, we have to work with the business teams. We no longer give what is called legal service, we give legal solutions. You have to be seen as a lawyer that as you are practicing your law, as you're implementing the law, how have you supported the business person to be able to lend money? It's not an issue of me saying, no, there is no this, I need that. If it's not done, you're not lending. I should be able to support my colleagues to appreciate the position of the law, the position of compliance with policy and regulation, but eventually support them to be able to advance money to their customers. Next slide, please. So my biggest role is that, yes, I will put this roadblock for you, but my intention is to see that, for example, if it is a car with the policemen that stop us, are your lights working? Are your tires in good shape? Do you have the driver's license that is required? Because I know that there is a likely danger of this loan not to return. And these are the risks that we live with. Risk management has taught us that there is an inevitable risk for whatever we do. Even us who are seated on this floor, there is that risk that we are sitting with, that this building could collapse, but we are seated here. So what are the measures that have been put in place? And that is what I do as a lawyer. Now, one of the things that I do where I sit every other day is advisory to the business teams. Now, Centenary has over 80 branches, and all these branches have a minimum of about 5 officers who go out to look for the business. And every day, there's something new that comes up. Every day, our customers are wiser. Our customers are knowing their rights. Our customers are being sharper, for lack of a better word. So every other time, we have to advise the teams that are out there looking for the business. Then, one of our cores is drafting all the legal documentation for the bank to be able to lend. Now, where we sit, we have to keep reviewing them, because I joined Centenary about 8 years ago, and I found documentation in place. But every other 3 or 4 years, we have to review the documentation. Number one, for conformity and compliance with the law. Number two, policy, because every other day, the policies of the bank are reviewed, they are refined for the better. And also best practice. We can also look at scenarios. For example, when we had COVID, we had to quickly step in and provide for all the moratoriums that the bank was going to give its customers. So that is not something we had envisioned or had known, but we had to work quickly to see that our customers are supported, the loans don't go in default, the bank does not fail to perform, and this is what we do on a daily as lawyers. And we do it to also make sure we stay relevant. I work in Centenary Bank. If a customer comes in Centenary and says, your paperwork is too much, if I want to access a loan, why don't you do it like so-and-so bank does it? So for me to stay relevant, a legal person is supposed to keep supporting the business teams to review these documents to ensure that we stay relevant and don't lose our customers. Then we're also in charge of the process of perfection of securities. This collateral that comes to the bank, we spearhead the mortgage registration. What do I mean by mortgage registration? When you come to us, one of the documents that you sign is a mortgage deed. Now, this is an instrument that enables me under the law to put my interest on your security. So I have to ensure that stamp duty is paid. I have to ensure that this mortgage is actually entered on your security. We support with the transfers, that those customers that we buy property for, and we do not allow them to do the transfers themselves. The moment we release money, we do the transfers, we do the perfection. Some of them we have to do releases of the mortgages or releases of caveats and so many other things in that space. Then we also majorly do the checklisting of credit files. For every financial institution or for every lender, there has to be a file that is created for a customer. Now, when that file is created, depending on the number of customers that you have and the different thresholds, there are those files that must go through the legal team. Number one, for correctness of information. Number two, for compliance with the law, policies and procedures, as well as best practice, and also to ensure that the approval conditions have been met, and to ensure that the disbursement documents are all in order for this loan to go out, that tomorrow, when something comes up, when there is a default, there is a fallback position, and that is documentation. Next slide, please. So, in our day-to-day work, these are some of the documents that we work with. You'll find an offer, a loan agreement, a mortgage deed, declarations into marital status, names, signature variances, the consents, the different kinds of consents as per the law, the different independent advice forms, the national IDs, the original documentation, for example, if it's a title or a land sale agreement, your passport size photographs, both your spouse and yourself as the borrower, valuation reports. There's so many documents that we work with, but these depend and vary on who the borrower is. Some of our borrowers are companies, some are individuals, but there's a lot that we work with. I may not be able to speak everything here, but we are here to support in case you want to know. And for those who intend to join in-house lawyer, work in financial institutions, we're here to support. Now let me delve to the rights and the duties of different parties. Number one, maybe if I can mention this, every other right is prescribed by law. Every other duty is as per the law. We do not have rights that we impose on ourselves or duties. For every other right that we exercise and for every other obligation, it is per the law. Now, both parties have a duty to disclose information. And actually, the law makes it an offense if a party does not disclose information. We've been through scenarios where our customers don't disclose certain information. The most interesting of all of them if I can give an example, is when we lent a customer, and this was about the 9th cycle. But you know, like I said, our customers are wise. They are becoming wiser and wiser. The customer is very good. First cycle, second cycle, challenges, third, fourth. Now, when the customer has an intention to defraud the bank, they will even serve 5 cycles. And then on the 6th cycle, this gentleman, being a Hajj, for the Muslims, you'll excuse me, but that was our customer. He came with the daughter, and the daughter signed spousal consent. Now, you have an obligation to disclose who your spouse is. And by the time we got to the bottom of what was happening, it was quite unfortunate. And the bank lost that case. But imagine, we're losing over 10 million shillings. We've even lost much more, sometimes because of non-disclosure of information. So it is a requirement by law that both parties act in honesty and in good faith, because we are into business together. Now, we also have a duty, the mortgagor has a duty to disclose whether the property that is subject of a mortgage is a matrimonial home or family land. Now, on our end, the duty is to conduct due diligence to ascertain if this property is actually matrimonial or not. I know that there is a lot of discussions, there is a lot out there as far as this duty is concerned. Banks, financial institutions have fallen prey of this. But as Centenary Bank, what we have done to protect the interests of our customers and our bank is that for every property you bring to us, we require spousal consent. Whether it is matrimonial, whether it is family, whether it is commercial, because at the end of the day, when we go to court and say, the customer said this property is not family, it is not matrimonial, we lose it. So we have categorized all landed property given to us as security to take spousal consent. And someone will ask me, who is a spouse? The law requires that I actually obtain a marriage certificate. But we have gone ahead, even those that are cohabiting, we have asked them to sign a declaration to that effect. They are not signing as legal spouses, but they are signing as people who are cohabiting with the borrower in form of a relationship that is a look-alike of a marriage. Because we want to leave every stone unturned. Tomorrow, when this loan goes bad, we should be able to protect the money that went out. We have a duty as customers to disclose our marital status. And so many of the customers do not do that. They come to us and say, me, I'm not married. So it is a duty, and we need to know as borrowers that it's an obligation under the law. Then borrowers also have a duty to pay the loans that they take. A customer is very good when they come to the bank to borrow money. You go through the process together. The moment you disburse the money, they don't even want to pick calls of officers. Or when they pick, they are quarreling on the other side of the phone. And then you ask yourself, what happened? You took the money, it's not your money. It is an obligation that you have, and you must pay back the money. And me as a banker or as a lender, I also have an obligation to demand for that money to be paid back. And there is a process by law that I must apply to get back that money in the event that the money is not coming back. Next slide. Yes, there are so many other rights and obligations. I may not necessarily go through all of them as agreed. The slides will be shared. So those are some of the rights and obligations. Allow me to go to the foreclosure process. I think because of time, and to allow us be able to engage in questions and answer. The Mortgage Act clearly spells out the process under which a financial institution can recover money in the event of default. The process is very clear. I zeroed down on specifically sale of property. There are many other remedies that are envisaged in the law, but because this is what is in the practice and this is what happens most times, I want to re-echo my statement. Financial institutions are not interested in customers' property, and I am firm on that. But we have an obligation to make sure that money that is lent out plus interest is recovered and returned to the bank. Now, the law provides that where money is payable on demand, that it is written to the customer to act. Now, what we do at the bank, in fact, we are very kind and very relational. 3 days to a loan installment falling due, we send you a message to remind you that your repayment date is coming. When the customer does not deposit money, definitely the system will pick nothing. So the loan will go into arrears. Now, when the 7 days hit, we just send you a courtesy reminder as the bank that your loan is due past 7 days. Kindly pay up your installment. Now, the law says that if this default persists for 30 days, then it is declared a default. You know, initially the loan is in arrears. That is the terminology that we use. At that point, it is in quotes in default, but it has not yet hit the 30 days to qualify it as a default. But when the 30 days hit, the financial institution must serve you notice of that default, now requiring you to rectify that default within 45 working days. Now, in the 45 working days, if you do not pay up, the law requires that we issue you a recall, which has also served as a notice of sale, now giving you another 21 working days. So the law has been very lenient, and actually, if I can speak to what is in practice, you find that some of these days get into 60, 70, 100, and the customers are not paying back. So we serve you this notice. Some of our customers actually disappear, but the law allows us to serve sureties, guarantors, children for customary law, spouses, the independent advisors. Next slide, please. Now, when the 21 working days elapse, and you have still not responded, we start on the process of sale. We go ahead and value your property. We actually advertise the property, and the advert is supposed to run for 30 days. So as we advertise, you know, some of our customers lay back until when they are alerted that your house is up for sale, or when bank auctioneers come to the property and start to spray property for bank sale. Of course, they definitely start to run, cry here and there. Unfortunately, customers shun the bank. They start running to lawyers, I need you to help me, my property is going, this and the other and the other. But because we have called on you, we have beckoned you to come, and we engage on what exactly is happening. Because when you take a loan, you have an obligation to pay. And every other day that passes when you have not paid, there is an interest that accrues and a penalty to that effect. So if you took 30 million, instead of paying, let's say 32 million, you find yourself by the time you default, you have run away from the bank, the loan has gotten into 40 million, you're complaining, no, this is not the money I took, and all that. But it's very important that when customers are defaulting, lawyers advise them Have you talked to the bank? Have you engaged with the bank? You find that we are seated and the lawyer is writing to us, you know, this customer borrowed this money, but the bank is being unfair to them. I demand that you share with me all the documentation, the balances. And we're like, anyhow, it's an interesting story. But what am I trying to say? It is important that as lawyers, we are not just looking at making money from these customers, because trust me, some customers don't have the money. Others do have the money, but it's a character issue. They don't have the money. Now, if they're spending the money with the lawyers to write to us or running to court, that amount of money can be used to reduce on the loan amount. But anyhow, the process continues. If the customer does not respond, we value this property. Because you remember the valuations that I talked about when we were going to lend? We're interested in knowing the open market value of the property as well as the forced sale. Because when a loan goes in default, most times the sale is a forced sale. So there is a variance in that amount of money. So at this point, 2-3 years down the road or 1 year, you find that the values have changed. Probably they have gone up or they are lower, but most times they're supposed to be going up. We appreciate the amount that this property attracts, and then we put this up for sale. When we get bidders, we get the highest bidder, and we sell the property, and we meet all obligations as per the law, and then we prepare an accountability of how we have distributed the proceeds. Now, the customer is entitled to all residues of the proceeds after all deductions have been done. I know that there's a lot that will come through in respect to this area, but it's appreciated, it's understandable. We're here to dialogue and learn from one another. But thank you so much. In conclusion, allow me read this statement verbatim. Every mortgage or credit facility has the potential to go bad. Not necessarily because the customer is a defaulter or fraudulent, though some are, but because of the economy we are in, the conditions and factors under which customers do business. They are volatile. They change any minute. So we have an obligation to protect your money. We have an obligation to protect the financial institution's money. And what I could add is that that's where I earn my bread. So I have to do my job. It is therefore important and it's critical that we all do our part. Financial institutions have lost money, of course, through technicalities. But I love one judge who told this customer, did money hit your account? Yes. Did you withdraw the money? Yes. Is it the same amount of money that the bank is claiming? No. Why do you think it's not? I don't know, they are cheating me. And the judge said, but no, you took the loan on interest. You're supposed to be paying back some money on top of what you took. So if you admit that you found the money on your account, even if you're claiming you didn't ask for the money or the process was add upon, you took the money, you withdrew it from the account, and you used it for whatever you wanted to use it for. Pay back the bank money. Thank you so much. Over to you, moderator.
Thank you so much, Mrs. Sharon Shaba Mwebaze. I see we are getting so many questions, which is a good thing. But given the structure of our remaining presentations, I would request that we have our next speaker first, and we can have the Q&A very extensively. So the next speaker, my senior colleague, Mr. Nangwara James, is going to talk about the role of lawyers in protecting clients' interests in mortgage agreements. He's going to give the practitioner's perspective. Then, related to that, he will also talk about the key considerations and legal safeguards in drafting pleadings and mortgage agreements, because as you're well aware, It's one side doing the mortgage agreement, and when things go bad, oftentimes we end up in court. So he will give us that perspective. So just to introduce our next speaker, he made it very clear he's a Salongo. He's a managing partner of Dagwala Resida and Company Advocates. He's a graduate from Makerere University and also with a diploma in legal practice from LDC. He entered the role of advocates on the 8th of November 1988. So you can imagine. His first PC was in April of 1989. He has been a lecturer at the Law Development Center from 1989 to 2009, at the time of which his departure he was a senior principal lecturer and also head of subject land transaction, and also he was a head BACOS. So as you can imagine, he has a wide experience in litigation, in not just these domestic courts of ours, but also he has appeared before the East African Court of Justice. He has appeared before the COMESA Court of Justice. He has represented and still represents financial institutions, and he also handles security documents, drafting security documents for the said financial institutions and also microfinance deposit-taking institutions and also foreign financiers. So I would gladly invite you to take the floor and make your presentations, Council. Thank you.
I have an assumption that all the listeners are knowledgeable in the law, substantive, and procedural. And if I made a mistake, Sharon, thank you very much. You have made the work easy. I don't think I would have departed from the law applicable as you presented it. Next slide. Now, maybe I'm a bit conflicted. Most legal private practitioners do not represent mortgagees. Mortgagees are mainly financial institutions, micro deposit taking institutions, and other lenders. Most intending mortgagors do not participate in the drafting of mortgage deeds. Mortgage deeds are either drafted by the legal department of mortgagees or their external legal service providers. They hardly have any input, and even if they had any input, it is either take it or leave it, because at the end of the day, they need the money. And I know that in most cases, they do not read the draft deeds presented to them for execution. Their work is, when am I accessing the money? In many instances, if not all, they only come to read the mortgage documents when the security is undergoing foreclosure and when the legal counsel they approach asks for them. Now, a practitioner needs to balance between protecting finance capital and loan capital. Finance capital belongs to the mortgagee, and the person who wishes to get loan capital is the mortgagor. In my opinion, protecting the former should prevail. We have to protect the rich against those who transpire to be rich. And even the rich it's not their money. It is either depositors' money, shareholders' money, or money from various lines of credit given to the mortgagees. Now, what are some of the salient features of a mortgage? We have the facility amount, the commission or processing fees charged, the rate of interest applied. It is annual, but usually compounded daily on daily balances and probably posted to the account of the mortgagee monthly. A mortgage deed will also have periodical payments, which could be monthly, quarterly, or annually. One of the issues I've encountered is that because different borrowers have different ways of access of getting revenue and paying back, they may request financiers to tailor their repayment to certain terms. It could be monthly, it could be quarterly, or it could be annually. But then the banker system, the financiers' systems may not be tailored to the particular needs, leading to premature demands and hence litigation. I think this is an issue which needs to be looked into. It also has a default clause, remedies, and remedies. Now, with the onslaught of technology, mortgage deeds these days are limited to 4 pages. I don't know whether they have increased the pages. So you have to compress all the do's and the don'ts in the 4 pages. Now, Sharon has already talked about the duty of the parties to be honest. Now we are talking of conditions precedent to entering into a mortgage agreement. We have consent from spouses. These are very difficult to, it is very difficult to obtain a genuine consent. Due diligence on this aspect should be thorough. Actually, you find that many of the cases, the majority of cases now brought against financiers are based on absence of spousal consent, whether real or faked. So one of the reasons is that many borrowers have one piece of property, and the borrower's spouse may not wish to take the risk. Another reason could be that the purpose of the borrowing is not genuine. It might be to defeat the spouse or engage in an unviable venture. When a couple quarrels and the other says, get out of this house, this one says, I came here to stay. Says, I will defeat you by using the weakest link, which is a financial institution. Now, in such circumstances, of course, there will be no spousal consent. It will be it will be by a proxy. We have polygamous marriages, especially the Mohammedan marriages. An unintending borrower may wish to play off one spouse against the other, or may wish to play off the financial institution by using the several of the spouses. I have quoted the case, Mariam Chiwanuka and Stanbic Bank. Here, the spouse who signed the consent was a genuine spouse of the mortgagor, but not staying in that house. Now, there was an attempt to argue that it wasn't their spousal consent. The court held that no, it must be the spouse residing in the premises who must furnish the consent. Now, again, there are conditions precedent when the intended security is a lease. Most leases provide that the leased property will not be mortgaged without the consent of the consent of the lessor. And there are many instances where the properties, leased properties, are mortgaged without the consent, and maybe the legal department of financial institutions may overlook that omission. But remember, that mortgage is voidable at the instance of the person supposed to give the consent. Again, for mortgagees, try to look at the duration of the lease. We have seen facilities which outlive the duration of the lease. And in the case of disposal, in the case of foreclosure, the disposal of the security may fail on account of maybe a lease taken when the remaining term is very short. Who would want to purchase such a property? It is always important to look at the duration, and maybe by policy, the financial institution should come up with a policy as to whether actually they should lend on leases, especially leases granted by private owners of freeholds and minor land. Leases granted by district land boards could be okay. The question is, will you be able to recover the money, all the money lent, on the basis of a security which is a lease? Another aspect, as a practitioner which I have singled out, is valuation of the security. There is always connivance between the intending borrower and the valuation surveyor. Land appreciates in value. The value at the time of foreclosure should not be lower than the pre-mortgage value. We have seen cases where fraud is alleged on the part of the mortgagee for a value at the time of foreclosure which is less than the value before, which is less than the pre-mortgage value. We know that land appreciates in value. So, please take a caution. Now, it is also important that the mortgagee understands, the intending mortgagee understands the nature of the facility applied for and tailor the mortgage and especially calculation of interest to such a facility. The most common facilities are loans, overdrafts. Loans are the usual ones. Lend me this amount of money, give me a period for payment, interest is imposed. Then the overdrafts. Actually, overdrafts is a facility taken out of caution. A person is allowed to overdraw his account to a certain limit. Now, interest is calculated on the overdrawn amount. Then guarantees and performance bonds. When you apply for a facility of a guarantee, or a performance bond, the presumption is that you are capable of meeting your obligations. It is only when you fail that, and the guarantee is invoked against the financial institution, that the financial institution may be forced to overdraw your account. So the security must specifically state it that way. Then there are letters of credit. Letters of credit are opened in respect of importers. The exporter would not want to start haggling with an importer who is thousands of miles away and would wish that a confirmed and irrevocable letter of credit is opened. But the letter of credit is not a loan or overdraft. It is only when you fail to meet your obligations that the bank is forced to overdraw. Either you have applied for a loan in advance, which you might even exhaust, or an overdraft, which you might even overdraw, but the security document must state those terms clearly. So it is common to find a mortgage created for all to be one for a loan, which is a mistake. Now, another issue which I have canvassed are leases renewed from grants by former controlling authorities. Article 239, well, former controlling authorities include Uganda Land Commission, urban authorities, and district administrations. Article 239 of the Constitution trimmed the wings of Uganda Land Commission and limited them to holding land vested or acquired by government. Article 241, Clause 2, district land boards are not subordinate to ULC and they are not answerable to ULC. Then Section 60, subsection 1C of the Land Act. Among the functions of district land boards is to take over the role and exercise the powers of the lessor in the case of a lease granted by a former controlling authority. Now, there are cases where there is bickering between ULC and district land board. You may find two titles on the same land, one arising out of a grant by ULC and the other one by a district land board. And in a certain case I know, and unfortunately, sorry to use this, the corrupt offices of the Register of Titles issues two certificates, one out of a grant by ULC and another one out of a grant by district land boards. At the end of the day, who suffers? It is either the financial institution, or the financial institution may comfortably create a security over such a piece of land, then sell it pursuant to foreclosure, and it is the third party, the purchaser, who will suffer out of it. So, whenever it is important to scrutinize securities brought to the financial institution, and if such a security is from ULC, where is the land located? If the function of ULC is to hold land owned or vested in the government, why would it issue a certificate of title to a private person? Would government, for example, have passed or authorized it. In most cases, it's just that people want to be relevant and maybe to earn some money. So financial institutions should take care. Next slide. Now, variation of mortgages. Variation of mortgages referred to in the Act is in respect of either the rate of interest or the amount secured or the duration of the mortgage or the covenants, conditions, and powers. See Section 11 of the Act. What I sing out of the variation of the 4 variations is regarding the rate of interest. The common practice of financial institutions is to place an advert in the papers. Take note that from such and such a date, the rate of interest applicable shall be revised from this rate to that rate. Now, does that advert conform to the notice required to be served on the mortgagor under the Act? This could be a risk, and the risk may result in losing depositors' money. I would rather the mortgagees make use of their relationship managers to ensure that the notice as required by the section is served onto the mortgagor. I know that as soon as disbursement has been made to a mortgagor, what the bank now requires is either payment or another mortgagor, such that relationship managers go to sleep when it comes to existing mortgagors. I think this needs to be looked at. Now, sale of mortgaged property by public auction. I think practitioners are aware of the procedure leading to a sale of the mortgaged property. Sharon has exhaustively touched on it. One problematic clause is found in Section 27(2) of the Mortgage Act. The mortgagee, that should be mortgagee, shall advertise the sale, and the advert may include the place and date of auction, being no earlier than 30 days from the date of the first advert. Now, most adverts do not include the actual date of sale. They simply state that the sale shall take place after 30 days from the date of publication of the notice. Does that comply with the law? Now, however, I'm sure courts should be mindful that the advertiser is a service provider. They also have their internal policies. They are not bound to advertise the security on the date required. It might come later, and when you have inserted a specific date, you may find that the advert may only run for less than 30 days before that date. So it is an area which poses a bit of a problem. Now, should the advert insist on selling after 30 days? But what does that mean? Does it mean on the 31st day? Or does it mean after 30 days, the sale can take place anytime thereafter? If so, I believe the advert should state so. If the mortgagee is to advertise a mortgaged property, if when recovery is not made on the specified date of sale, then and yet these costs are passed on to the mortgagor, the cost of borrowing would be too high, and I don't think the draftsman could have intended that. Now I would look at the key considerations and legal safeguards in drafting mortgage agreements and pleadings. Now, this is an area which requires extreme professional caution. In my opinion, it is a vote of no confidence if a deed drafted by an advocate is shredded into pieces by cross-examination due to lack of clarity. It is also a vote of no confidence if an advocate's professional indemnity insurance is invoked due to professional negligence. I also believe it is a vote of no confidence, and it is very uncomfortable if a preliminary objection is successfully raised against one of the pleadings. And that's why caution, extreme caution, must be taken when drafting. Now, drafting a mortgage deed. A mortgage deed is a contract and therefore must comply with the principles governing formation of a contract. The drawer must know the law governing not only mortgages, but also registered land. The drawer must know the established precedent affecting mortgages, and that's quite key, such that, and by these days, we have conflicting precedents. Maybe you take the most properly reasoned one. Some of them are made by with ulterior motives behind the decision. It is also important for to imagine that whoever goes for a borrowing is likely to default. In fact, I have always advised that banks should approach every borrower with the presumption that the person has come to cheat the bank. Lenders are presumed to be rich, and yet in all cases, they use depositors' money, shareholders' money, or even loan capital from certain lines of credit, like I've already said. This money must be protected. Execution of a mortgage must be properly done. You remember the case of any part versus general parts. Billions of shillings were lost, even in Zimbabwe and Orient Bank. Among other reasons, improper execution. Now, before drafting a mortgage, one must understand the instructions given to that person to prepare the security. You must understand the nature of the credit facility for which the instructions are given to draft a mortgage. In the case of doubt, we are all not bankers. Neither do we have extensive knowledge of banking practice. So in the case of doubt, seek clarification from the credit department of the client. Ensure you have a command of the law applicable on the nature of the credit facility. If it is a loan, an overdraft, a revolving fund, a letter of credit, you must know the law, how it is governed before you venture into drafting as Mr. Know-all. Then know the nature of the security given to you. That is the title. Understand the tenure. When did the owner become registered? If the owner has just recently got registered, and then the owner is immediately presenting that title as security, just like is selling, you may have to caution yourself and do double checking. Why are you presenting? Why are you immediately borrowing? Is it because you generally want to borrow, or you want to obtain money for purposes of getting rid of this property which you may have conned somebody of? So you must know KYC. Is it an individual, or is it a corporate personality? If the borrower is an individual, is he or she single or married, and to how many wives or husbands? Ensure that all these individuals are interviewed, actually cross-examined, for purposes of ensuring that there is no error. Their IDs must be obtained and other documents. Ascertain the use of the land, whether residential, commercial, agricultural, or industrial. Sharon said that the practice of high employer is to get spousal consent for every security. I don't know whether companies also get married. Maybe she will answer. Now, if the owner is a company, look at the constituency documents. Find out whether there exists, in addition, a shareholders agreement with restrictions on borrowing, even restrictions on pledging property. Remember, the articles of association are the internal regulations of a company. And if you lend contrary to them, and you as a lender, you are deemed to know the public documents of a company. Carry out a search on the file with URSB. The borrower may have borrowed from another financial institution which obtained a floating charge over the company's assets, present and future. Now, the security being presented, if there is such a floating charge, it is already a security of another lender. So it is important you carry out this diligence. Has the intending borrowing been sanctioned by registered resolutions? Next slide. If the intended security is leasehold land, who is the lessor? What is the remaining term of the lease? What are the covenants in the lease? Do they allow borrowing by the lessee without consent? If not, has the consent in writing been secured? You may even have to call, because consents may be forged. Inquire from the client whether it has weighed on marketability of such a security. The general practice is that people don't want to buy leases because it is ownership of land on contract. Do this, don't do this, and for a limited time. Is there a valuation report? What is the physical description of the land in the valuation report? You may have to ascertain whether the signatory of the report did the actual valuation. Field surveyors tend to attach a value as instructed by the intending mortgager. Actually, ensure that the firm has a professional indemnity insurance, but remember, insurance companies also don't want to pay. And find out whether there is a such report. Now, note, while a turnaround time should be respected, it is the duty of the legal practitioner to protect the client's money. The Mortgage Act introduced a number of restrictions which must be checked, and if possible, with precision, or in as much as possible with precision. I know that certain financial institutions, or one at least, had to take away instructions from me, having brought the security perfection by an intending borrower who was difficult. When I asked, and the amount of money which was sought to be borrowed was quite high. When I said I am insisting, the person went back to the financial institution and said, that lawyer is slow. I'm going to another institution. And the security perfection was given to another firm. Only later for the financial institution to present instructions to defend them because they had been conned. And of course, being what I am, I said no. Mortgage of a matrimonial home, Sharon has already talked about that. If the intending borrowers jointly own the land or their tenants in common, depending on the use of the land, each of the joint owners' spousal consent may have to be obtained. Instead, it must be remembered that Section 39 and 40 of the Land Act, which talk about family land is wider than matrimonial property. Maybe the practice of Centenary Bank is the best. Presume that all land is family land, therefore requiring spousal consent. Now, the mortgage deed itself. The deed should have a title, which could be the law under which it is made. Ensure that the land is properly described. It must reflect the names and addresses of both the mortgagor and the mortgagee. The amount to be secured, for what purpose, and for what duration. It is important that, notwithstanding the duration, and this is very important, the amount must be payable on demand. In other words, the amount may be disbursed today, and 2 days later, the mortgagee receives information that incidentally, that money was borrowed for this particular purpose. But actually, the man is organizing a wedding. Demand for the money immediately and go through the processes of recovery. This term is non-negotiable in a mortgage. Sorry. What is happening? Scroll. Another slide. summarize many of the key covenants by the mortgagor. No, wait, is there a slide before that? Yes. The installments, the amount is supposed to be paid in. By which period, when each installment is supposed to be paid, and when the subsequent installments are supposed to be paid, which is supposed to be on the same numerical date of the subsequent month, following the repayment of the first installment. Specify if the installment includes interest or whether interest is separate. It is important that the mortgagor knows what amount the mortgagor is supposed to pay monthly. You may also add that in addition to the installment, any commissions and ledger charges are also recoverable. Specify the interest rate and how it is to be calculated. Specify the penalty interest on arrears and at what rate. Incorporate other agreed terms in collateral documents in the mortgage by reference. Because the mortgage is 4 pages, you may give out this facility in a facility letter, which should be very elaborate, imposing various conditions. Now, incorporate all these other documents into the mortgage by reference. Summarize many of the key covenants by the mortgagor, including inspection, regular inspection, insurance, and handing over vacant possession of the property in case of foreclosure without applying to court, and that the mortgagor must specifically agrees to that term. I know our police force insists always on getting a court order pursuant to political declarations or promulgations. You must get a court order. Although the Mortgage Act says you must hand over the property, but that's for another day. Expressly put all future costs of enforcing the security on the mortgagor. That's the cost of borrowing. Ensure that there is a clause mortgaging the property to the mortgagee, not mortgagee, to the mortgagee to secure repayment of the money extended to the mortgagor. You see, you may have drafted all, but forget to put a clause that, and for better securing of the money herein advanced, the mortgagor hereby mortgages this property to the mortgagee. Ensure that there is due execution of the mortgage. Ensure that before perfection there are no missing fields. You don't take your mortgage to the Registry of Titles when there are missing fields, there are no debts, the money is in figures and not in words. A defaulting mortgagor may use any excuse to impeach the mortgage. In as much as possible, pay the duties by electronic transfers. Cash is very tempting. Next slide. Drafting pleadings. I don't know why this was also included in this subject, which is to do with the land and the mortgages. I'm not so sure whether the pleadings are limited on mortgages. Remember, I only defend mortgagees, not mortgagors. If it is general, in a summary, not the law governing the cause of action, both substantive and procedural. If a case in a defamation is brought against you, and you are pleading, say, on such and such a date, the defendant falsely published an article against the plaintiff to the effect that the plaintiff is a thief, no cause of action. Not the rules governing proper drawing of pleadings, Order 6, 7, and 8, and so on. If it is a constitutional petition, not the relevant provisions of the Constitution allegedly flouted. Not the procedural requirements are the constitutional petitions and reference rules. I'm being too fast. I was too fast because I believe this should be maybe in the civil proceedings week, not this week. Next slide, if any. For any other subject, for any other cause of action which is the subject of pleadings, find out whether there is principal and subsidiary legislation covering the subject. And for plaintiffs, be in the know of the requirements under Order 11 of the CPR. Don't forget to state the facts constituting the cause of action, and in bold, when it arose. If I don't find the date when the cause of action arose, depending on my moods, I may raise an objection that maybe this action is limited by time because it does not state when the cause of action arose. For defending, admit where you have to, deny generally what you have to deny, and please supply your defense, which is the answer to the claim. Is there any other slide? Thank you very much. I hope I've been relevant.
Thank you so much, Mr. Nangwara James. Wow, I must say, mortgages is a whole different ballgame. But just from the few I learned from both the presentations you made, was that one, you really have to know what you're getting into with regarding to the subject matter, with regarding to the clients, with regarding to how you're going to secure the security, how you recover in cases of default, and all that kind of stuff. From my personal experience, I must say it is never an easy situation you want to find yourself in, where you're either before court and someone is raising a PO, then the judge looks at you, you look at your colleague, the colleague looks at you, look at the client, or when you're in your chambers and pursuant to having transacted, the client comes back and says there is this issue and this, and you're short of words. So it's really key. Now we shall go to the Q&A. There are many questions, but I want to first start with the chat. If you could help me scroll up, there are certain questions that came in earlier on. Yes, starting with the there is a question from Dora. She says, is it a requirement for both the mortgagor and spouse to sign an independent advice? I think that could be either for Mrs. Ashaba or for senior.
Thank you. Okay, thank you so much. But first and foremost, allow me to appreciate our senior for such an elaborate discussion and exposure on what is happening out there, the realities that we live with, and the pains that bankers go through and financial institutions I would also want to inform us that financial institutions don't work in isolation. Even when we have legal departments, we still collaborate with external lawyers, external counsel, and practitioners. So it is an opportunity, or it's an obligation for all of us as lawyers and advocates, both in-house and external, to support one another. At the end of the day, when we are drawing our agreements, we do a lot of benchmarking, we do a lot of outsourcing for support from external counsel. So what Senior has presented to us is very insightful, is very eye-opening, it is very knowledgeable, and it requires all of us to go and do our homework. That notwithstanding, the question in respect to, is it a requirement for both the mortgagor and the spouse to obtain independent advice? Yes, it is a requirement as per the Mortgage Act that us, the financial institutions, advise our mortgagor to go and ensure that on top of advising and giving them that independent advice, we are supposed to task them to advise their spouses to go ahead and obtain that independent advice. I also mentioned the Bank of Uganda Consumer Protection Guidelines. The guidelines also make it an obligation for both the mortgagee, the mortgagor, and the spouse to ensure that all these parties have gotten the independent advice that they need to be able to appreciate the terms and conditions of the mortgage agreements they enter in. But I want to re-echo what Senior has said. Most times when this is happening, the customer is only interested in the money. They are not interested in the terms of the documentation, and they don't care. All they want to see is the loan amount, is it in what they want? Is the security what they have given you? Some of them, every other thing is not important. They want the money and that's it. And then it's a whole different ball game when the loan is in default. There is a lot to learn and a lot to take home, and for all of us to do our homework. I don't know if I can go to the other questions.
Maybe we can take a couple, maybe two to each, then we can respond in intervals. There is a second one by for Mr. Turinda Mujisha. He says, "Good morning. Thank you for the presentation. It would also be insightful. It would be insightful if discussions were made regarding fraudulent activities from the bank side. It is now judicial notice that bank officials, together with alleged fraudsters, do all they can to deny a mortgagor." I think he begs the mortgagor to redeem his property. Then there is another one from Mr. Andrew Barasa. He says he's asking for your opinion on the bill prohibiting attachment of borrower's property, and how would that affect mortgages, especially where property is used as security. Then I think we can have those two, then we can get more questions. Thank you.
Okay, thank you. Allow me start with one that talked about marriage spouses, that we actually go ahead and verify the marriage certificates at URSB. The answer is that no, we do not do that. Like I mentioned earlier, we both have an obligation to act in honesty and in good faith. Unfortunately, when we have to verify every document that a customer brings to us, the cost of borrowing goes so high. You see, we only do searches for companies. We don't even do searches for titles presented to us. Now, to manage that, we say we are not going to advance the money before our mortgage is registered on the title. That is all geared towards managing the cost of borrowing, because at the end of the day, if a customer comes for 50 million and they take home 35 million, the likelihood or possibility of not paying that loan back is high. Because of the complaint, I asked for 50 million, I'm getting 35 million, where is all the 15 million? And then I will get to the bill prohibiting attachment of borrower's property. It is unfortunate that some of the things that have come out as per the bill, right now it's still a bill. My opinion is that it is not a fair bill to lenders because our core business is lending, and our biggest securities are landed property, and most especially registered property. In fact, most institutions are running away from customary or unregistered land because of the many issues that have come up. The default rates are very high. There are so many owners of properties. There's a lot of connivance with mortgagors and their spouses. So most institutions are running away from unregistered property. Of course, we are having issues with registered property as well, but the levels at which we are having issues with registered property is not the same as unregistered property. But we are doing what it takes to manage the risks that are involved, but this is our core of the business. And I had mentioned it earlier, that our customers are wiser. Senior has even said that we should regard all customers as thieves as they come to us, which is unfair in a way, because sometimes we have built a relationship with some of these customers, and their credit worthiness goes without saying. It is good. So we are tending to get to those levels where we are sure, or almost sure, that the loans are going back. Even then, we can all see what we are going through economy-wise. Customers are defaulting, and we are mounting a lot of pressure. Now, if our fallback is the security, which is one of the C's that I mentioned, collateral, it's very critical. I do not know how we are protected, but I'm very sure stakeholders are being engaged, and bankers under the Bankers Institute is supporting us to see that the interests of financial institutions are covered and protected. Because what we're doing is part of the law. So if they intend to prohibit those attachments, then they're going to have to revamp the whole law, but then have a solution for financial institutions. And I'm sure we shall respond as required as financial institutions. And then the other was, kindly remind me, because what I picked was different. The connivance. I do not agree that it is on judicial notice. Why? Because financial institutions have zero tolerance to fraud. I will not deny that there are circumstances or situations where our staff have connived with fraudsters, with our service providers, to deny customers their rights under the law. But I would want to bring it to your attention that the financial institutions have taken, I will speak about Centenary, we have taken all measures and have taken through all staff that have found guilty of these occasions, of these offenses and frauds and crime, to book. They have paid as they are supposed to pay for what they have done internally. The procedures have been taken internally as well as externally. Some of these staff have been taken to courts of law and prosecuted for their involvement in these frauds. So I do not agree that it is on judicial notice. I do not disagree, it is happening, but the banks are doing whatever is within their mandate and the law to bring whoever is involved to book. But I also want to advise the lawyers out there that financial institutions are open to engagement. We're not in the business alone. If something has happened and it has come up, our offices are open for dialogue and discussion to resolve matters. And that's why I said we do not work in isolation. Lawyers do write to us if an issue demands that we discuss, bring issues on table. We have done that. We have solved customers' problems. We have given solutions, we have sorted out customers' problems, but like I mentioned, the economy that we work in, the country that we are in, is very volatile. So many things are happening. But it's unfortunate where we see the lawyers that are supposed to work with us, in a way also supporting customers not to pay back bank money. But that notwithstanding, we've also seen our customers conniving. I would want, in fact, to speak to the issue of valuations that Senior mentioned, that there is a connivance at the tail end when there is a default of auctioneers conniving with whoever it is to devalue property. The circumstances where you find, most circumstances where you find the value of the property is less than the time of the valuation at lending, there was a possibility of connivance of the customer with the valuation surveyor because they want a higher loan amount and they are sure that their property does not add up in terms of collateral value. The customers connive with the valuation surveyors, and you have seen out there that some valuers have been dropped by financial institutions, some valuers have been taken to courts of law, and their peers have been evoked. Unfortunately, the peers we hold are annual, and you find that a case goes into default after 3-4 years, and by the time you pull out the valuation report, you no longer have a PI that covers you as a financial institution. So you're only left with taking the valuers to court and see what comes out in supporting you have these loans repaid. But I would want to re-echo that lawyers, we need to work together because financial institutions depend on your services and support. There is a lot of wisdom in quotes with our customers, and where they see the gap, they take advantage. But the bottom line stays that there is money that was advanced, and that money must be paid back. So my appeal is that we work together to refine our documentation, to refine our pleadings, to even sensitize our customers. Thank you very much.
Thank you. Right on cue, there's a question for you, Senior. Mr. Sarangapo Moses says there are contradicting precedents. He's seeking for advice. What are some of the more grounded or reasoned precedents that they should rely on when dealing with mortgage matters? Then secondly, he also goes on to say, as a condition precedent, one has to get spousal consent before borrowing. What happens to those that are not married and or other legal entities like companies, etc.? I think that's what you hinted on it, but if you can answer the first one where he's talking about reasoned precedents. Thank you.
Yeah, thank you for the question. I cannot single out precedents lest I bias the listeners. However, like I have always opined, when judges are giving decisions, they are guided by the law. And the law applicable, how they are supposed to apply it, and the hierarchy is found in section, I think 14, subsection 2 of the Judicature Act. Good enough, the law governing mortgages is laid down in statute. Look at the precedent and find out, has statutory law been applied correctly? Has it been interpreted correctly? If the judicial officer in a case chose to give an own opinion, and that opinion, and many practitioners take those opinions as law, and yet there is a guideline, I would rather you stick to the law, which is written law, and insofar as written law does not apply, then you go to common law, doctrines of equity, established custom, and usage. If a decision is inconsistent with the law, certainly even if it was not appealed, it's a wrong decision. On the question of intending mortgagors who are not married, first of all, marriage is not compulsory in the country or anywhere. There could be intending mortgagors who are genuinely unmarried or divorced. The issue we're addressing is doing proper due diligence. There are many who come up and say, actually, I'm not married. And yet when you look at the person, he's marriage material. Really? Especially gentlemen. Before you take his words at face value, please do proper due diligence. Find out from contemporaries, find out from neighbors independently. It's like, what happened to that guy's wife? The wife is there. Then regarding companies, I believe that is the only intending mortgagor who does not need spousal consent. However, the corporate personality may have constituent documents which require that there must be approval by the majority shareholders, or there must be consent, there must be a resolution. Ensure it is in place. Otherwise, companies don't have marital attributes. Any other question?
Senior, as I get this next question, you can look to the chat. There's something for you on a lighter note as I get this next question. There's a question from Mr. Omara Daniel. His is in relation to stoppage of sale of mortgage property. He says he's seeking for your interpretation. The panelists, we can get both of your interpretations of Regulations 13(1), 4, and 5 of the mortgage regulations in respect to security deposits, in relation to adjournments or stoppage of sale. Then there's also, when you scroll down, there's a question from we can have you. Yes, there's a question from Mr. Henry Barwani. He says, my name is Henry Barwani. Default of mortgages many times is due to reduced repayment ability, and mortgagees are quick to commence foreclosure, and when mortgagors run to us as lawyers, we sue to save the mortgage property, but the law now provides for 30% deposit to sustain the grant of an interim injunction. He says he finds this 30% deposit unfair, especially to mortgagors who cannot raise this money, who end up losing their mortgage property, creating untold misery. He's asking for your thoughts in relation to this requirement for the 30% deposit. So we can have those for now. Thank you.
Yes. My land friend, Mr. Walwanyi Magino, I believe, in my opinion, I believe the percentage should be even increased. One, you went to access depositors, shareholders' money, knowing very well that the shareholder, the financer, has got employees, has got operational expenses, and it is out of interest and repaying back that the financer is able to sustain its existence, and now you have defaulted. The financer may also have obligation of repaying money obtained from lines of credit. So if you start giving excuses for not paying, and yet you took you took the financer's money, why shouldn't your property go if you are not able to deposit the 30%? It is mandatory, and in my opinion, the rules committee which made the rules was lenient in imposing a mere 30%. Don't borrow unless you have the capacity to pay. Any other question for me?
I would also want to add on to what Senior has mentioned. For me, on my side as an in-house lawyer, I see this clause as a deterrence of sorts of customers who intentionally do not want to pay bank money, but want to spend all the money out there so that they don't pay back. Now, for me, I think I agree with Senior that this is very low, but I would advise that you would rather take that 30% to the bank and reduce your loan obligation. And we discuss, because we have processes where we reschedule loans. We welcome any payments that have been made towards the loan. What challenges financial institutions is how a customer does not want to pay, but is willing to spend money elsewhere. Yet this money can be reduced, can be used to reduce the loan amount, and probably enter into another arrangement for a restructure of their loan to enable them have smaller installments for them to be able to pay up the loan and also redeem their property. Thank you.
Probably, as an addition, you see, when you don't pay, when you default on paying the mortgage sum, financial institutions are required to provision for the money which is not paid for. In other words, they must get money from their own sources to cover your money, which is an undue operation on the financer. So why should you complain about 30% when the financial institution is provisioning for 100%? Please, your statement that it is too much and the person cannot pay. When your client signed the mortgage, he must have foreseen the natural consequences which flow from not paying, which is that the property must go. Thank you, sir.
Thank you, Senior. We shall get 2 more questions. If you go down, if you help me scroll down, there was one on. Yes, there's a question from. There was one on from Miss Nadunkuma Sumaya. She says, in instances of salary loans where the loan is duly repaid and the bank refuses to remove the code, I don't know what she means by the code, and continues to deduct the client's money, what administrative procedural steps can be taken by the borrower? I think for you, that's for you, Mrs. Sharon, as in-house counsel.
Okay. If I could just repeat that, in instances of salary loans, I hope we are all familiar with salary loans, where the loan is duly repaid, the bank refuses to remove the code and continues to deduct the client's money. What administrative procedures, steps are taken by the borrower? Number one, I do not understand what the code is, but probably the lawyer is saying that if the loan has been fully paid. Now, I would wish to speak to our systems that the banks run. The loan systems that we run are designed in such a manner that when the loan falls due, it is due, and when it is paid, it is fully repaid, and the system closes it. Those circumstances and scenarios might happen, but I do not think that that is the trend. They might happen, And when we have such occurrences, I want to believe sometimes they are isolated. The advice would be that the customer approaches the bank. And when these customers come, I insist on a situation or an issue of dialogue. The challenges that we have is that our customers are afraid of approaching the institutions to lodge their complaints. Some of them would rather go to social media, others would rather go to lawyers. But if we have a relationship with our customer, it is important because we acknowledge when the fault is on our side, and we have refunded customers where the loans have continued deducting money on their accounts when the loan is supposed to be fully repaid off. When we are giving you these loans, we give you a repayment schedule, and your last date, depending on how you have repaid the cycle. Sometimes customers don't pay on time, and when penalties have been attracted and deducted, for them they continue looking at their loan schedule with the assumption that what is on the loan schedule is what is supposed to be reflected in the system. So they compute the total amount as per the loan schedule, and then they forget the moments where they have not paid on time, and then they come to complain. Customers are taken through that process, and where the customer does not agree or where the bank acknowledges that it's our system, we have refunded back customers. So I would wish to encourage each one of you and colleagues that let's have these engagements. There is a lot of resolution that we find in engagement. Sometimes these things are an oversight on our end. Thank you.
While I still have you, Mrs. Sharon, just two questions from me, maybe then we can go on to something else. One, you talked about challenges that you face. How do you address some of these challenges? Maybe if you're faced with clients who default and you realize maybe the bank was defrauded, there was a lapse in maybe the due diligence and you cannot recover the money. How do you deal with these challenges? And then two, you talked about the issue of due diligence of knowing the client, the person who comes to take out a mortgage with the bank. There was an aspect of the credit score. How intrusive is this to one's privacy? Are there data protection issues, privacy issues of, if I'm coming to borrow, do I want each and every person to easily click on a system and access all this personal information about me? What is available on this? Thank you.
Okay, thank you so much, moderator. Number one, on the challenges that we face and how we deal with them in respect to non-repayments of loans and total default. First and foremost, we have been able to foreclose on property to recover our loans. And as Senior says it, the property must go. If the property has to go, it will go. I will not use the same tone as he does because I sit on the side where I need the customer to come to me tomorrow. So I must maintain a relationship. And secondly, unfortunately, like Senior mentioned, we do provisions. It means there is money that has been picked from somewhere and it affects the bottom line of the institution. That is the ultimate profit for the year. If these loans are not paid up, that money is used to pay up these loans, which has affected the profit or affects the profit of the institution. And then we have also done a lot of sensitizing of our staff and customers. We do a lot of trainings. We do a lot of eye openings to our customers and to our staff to ensure that all stones are left turned for us to see whatever risk is underneath. Of course, some of these we've had to live with them. The institutions have made these losses, but we keep in this business together and we pray. But we have also presented some of our concerns through our association, the Uganda Bankers Association, where we meet as the industry players and we discuss the challenges that we face and advise one another on how to go about it. Some of our decisions have influenced policy, some of our decisions have influenced the law, and this is some of the ways that we try to manage the challenges that we face when these losses come. We have also gone to court. Some of these customers are fraudsters, and we have to use an iron arm on them. We have gone to court, we have sued them, we have arrested them, we have made their lives uncomfortable, and money has come. But we have to, of course, invest a lot of money to see that these loans are paid back. So my beck and call is to work together. You know, when these customers run to the lawyers, and the lawyers also come with a lot of energy from us, you find a notice of intention to sue of someone who has failed to pay 500 million, and the lawyer is asking for 50 million for writing the letter. Then you start to wonder, are we in business together, or the lawyer is out to just earn from a problem? So I really request that we work together as colleagues, because these banks are there, they are using your money. When tomorrow you come, you want your money, the bank cannot tell you that the other customer did not pay. You'll want your money there and then, and before you know it, we're in social media, we're not giving you your money. So let's work together to see that we support these financial institutions as they lend out money. Then data protection, the credit scoring. One thing that we should not forget, I keep re-echoing this, that financial institutions are regulated, and heavily regulated. The Bank of Uganda is not seated every other time we have audits happening on compliance. Number one, we already have the data protection laws in Uganda, and financial institutions are one of the first action stations. So the credit scorings that you see we receive, all this is information, and besides, they receive this information from us. They are equally licensed by Bank of Uganda. So they are equally audited on the compliance levels that they put in place. And financial institutions are fined heavily, penalized heavily for non-compliance. So we have put in place measures, procedures, systems, and controls to manage all angles that could cost the institution a penny. Thank you.
Lastly, with you, Senior, there's a question from Mr. Christopher Chidega. He has insisted that this question has not been answered. I may have a different view, but we shall have it all the same. He says, is a spousal consent required for a loan to purchase and develop family land? That will be your number one question. And lastly, it's about your passion for the mortgagee. When you were beginning this discussion, you had said you feared you are biased, but in the midst of your discussion, I felt you are a bit balanced. But at the end, you've come out with vigor to say you're more or less for the mortgagee. You've made it clear that for someone, when you come to borrow, you know the consequences. If you can't pay, then the property has to go. So don't get into what you cannot finish. So just that question, and also what inspires maybe your passion for the mortgagee. Thank you.
Now, Mr. Chidega, is spousal consent required for a loan to purchase and develop family land? When you look at the definition of family land, it includes land where people intend to make a home. So spousal consent to me is required even for a plot of land, especially one where the people intend to make, to establish their own home. On a lighter note, this could be scientific. I don't think mankind was meant to sit in offices, drive cars. I believe mankind was meant to be a physical worker, was meant to walk, the body was meant to be active. I try as much as possible to lead a peasant life. Maybe I want to imagine that explains why you think I've not changed, but I believe I've changed a lot. Is there another question?
So thank you, Senior. With that, we thank all our speakers today, the presenters that we had, and the ones that we have right now. We are seeing a lot of thanks from the group chat. There is one, again, in particular, I know one of us here would be interested in, from Mrs. Doreen Ngwara. This has been a very insightful session. Thanks to all the presenters. Mr. Ronald Matovu says so much. So we thank you so much. Personally, it has been my first time moderating such an occasion, and it's been very insightful. So I'll end as I began, thanking the Almighty God for having convened us here and having given us a nice session. We wish you all the best and God bless. Thank you.
All right. Kindly taking this opportunity to thank our speakers for the day. We thank our senior, Mr. Nangwala. Thank you so much for accepting to be here. Sharon, we truly honor your presence here. Thank you for taking off time. And earlier we had Miss Bernadette. We also thank her very much. She's not here, right here, but we want to thank her. And Alan, thank you so much for taking your time off, your busy schedules to just make it here, to just make sure that our members, our participants, get all these skills and the knowledge. We don't take it for granted, so a hand of applause for our speakers. So thank you so much, even our participants, for the day. Thank you also for making time, parting with your money to make sure that you attend and get this knowledge. We're not taking it for granted. I also take this opportunity to thank my council for this opportunity, my acting CEO. I don't take it for granted. And now I also take advantage or this opportunity to talk about remedials. Some of our members who are not able to accumulate the minimum 20 CLE points for the year 2024, you have to take note that it's not the Uganda Law Society that is granting the remedials or the grace period. Each individual who didn't make up the hours has to write individually to the Law Council through the secretary, and then you indicate the reasons why you are not able to. But I know there's a committee, the Continuing Legal Education Committee, CLET, that sits on a monthly basis to look at all the applications and make sure that everyone is considered and given maybe a period. They communicate formally and write back. So each one who is not able to accumulate the hours, kindly put it in writing to the Secretary Law Council and you'll be considered. Our next trainings, for those of you who may not be aware, or as you saw the calendar that we shared, our next training will be next week on 26th. It's on family law. It has 5 CLE points. It's also going to be an online training, and it will be 100,000 for our members, and then young lawyers, it's 70,000. End of this month, on 27th and 28th, we'll have climate justice training. It's 2 days. It has 10 points. It's going to be highly subsidized because we're having somebody who is slotting in to, partner with us. So there are going to be limited slots. So would advise, if you're really interested in attending this, kindly pay up as soon as you see the email communication. So I thank you very much. I also speak about the membership payments for the year 2025. You realize that now we are going digital. We are now digital. So the receipts, as you pay, they are sent to your emails. Those receipts don't have to be certified. You can just print it off your email, and that receipt can be submitted to the High Court as you apply for your practicing certificate. For the IDs, yes, those ones have to be certified. So you can send us either through email or on WhatsApp. We can make copies on our end, certify them, and then send them back to you. So we're trying to make it as easy as possible, as smooth as possible. So the High Court, the Chief Registrar's Office is well aware that we are now issuing e-receipts. Some of our members keep on asking, why haven't we certified them? But now the High Court is fully aware that these e-receipts are there. Also speaking to now our members, our trainings which are coming up, we always call upon you, if you're able to speak to any particular topic or any particular area of practice, kindly get to us so that we can see how we work together and make these trainings of ours very knowledgeable, very skillful. With those parting shots, we thank you very much and have a great afternoon. Thank you.